जजमेंट आ रहा होगा, एक पैसेज कोट करना आएगा जैसे प्रोनाउंस करना.
From supplementary is for final dismissal item 3 WPC 264 of 2018 along with item 4.
In this case, madam, the contention of the petitioner was that since the order passed by the circle officer was pursuant to the direction of the deputy commissioner, so if they prefer an appeal before the LRDC under the mutation law, then that will be prejudiced and influenced. So, madam, kindly have a look at that order of the deputy commissioner. Deputy commissioner has categorically said that the CO will pass the order. जांच पूर्ण होने तक किसी प्रकार की कार्रवाई नहीं किया जाए. अतः उपयुक्त लास्ट आई एम रीडिंग द लास्ट पैराग्राफ. अतः उपयुक्त तथ्यों के मद्देनजर एनेक्स 7 पेज 67. अतः उपयुक्त तथ्यों के मद्देनजर निर्देश दिया जाता है कि अभिलेख में सभी तथ्यों की जांच कर नियम संगत कार्रवाई हेतु उचित माध्यम से उसे प्रेषित किया जाए तथा अपर संवाददाता धनबाद के प्रासंगिक पत्र संख्या सेक्शन 6 के आलोक में जांच पूर्ण होने तक किसी प्रकार की कार्रवाई नहीं किया जाए. So he has categorically directed to make an inquiry first and then to pass an order in accordance with the law. So this contention of the petitioner that appeal, if they prefer before the LRTC, that is prejudiced, that I refute, matters. And there is a specific provision for appeal, so he must prefer an appeal.
याद करेंगे भूल गए. Just
Your Lordship may kindly see that my second supplementary affidavit, Your Lordship may kindly see. It is, I'm placing from WPC 265. Your Lordship.
264.
265. Although this affidavit is in both, and because there were, my vendor had sold the property in by two sale deeds to the same petitioner. Therefore, two separate mutation cases are there. Your Lordship may kindly see this affidavit is dated 38/2022, and in this, during the pendency of the writ petition, we had also applied for removing our name from the prohibited list. So what the circle officer does, that letter dated 29/7/2022, Your Lordship may kindly see. First, he has already rejected my mutation, but what he says here, absolutely entire thing in my favor.
Page number?
Page number is 8 of that affidavit.
8. Yes.
Second supplementary affidavit, page 8. May I read? It is 2 pages. Entire thing.
No, just like the earlier order dated 21/1/20.
Yes, that also.
Same.
Same, but here he again reiterates. Your Lordship may kindly take note of. In first paragraph, he says that the one Atikraman was initiated against me, that was dropped. Then what he says, राजस्व कागजातों को जांच के क्रम में पाया गया कि प्रश्नगत जमीन की जमाबंदी टिपुरी सो एंड सो में हरिलाल चावड़ा के नाम से कायम है. हरिलाल चावड़ा ने उप जमीन केवाला दलील संख्या इतना 17/250 के द्वारा धनजी राम श्री राठौड़ को 1 बीघा इतना बिक्री कर दिया. तत्पश्चात धनजी राम राठौड़ ने केवाला संख्या 11/6/1954 के द्वारा चीमन लाल खंगारजी चावड़ा को रकबा इतना बिक्री कर दिया. चीमन जी सो ने उप जमीन भूमि पर अपनी पत्नी एवं पुत्रों के बीच अपने जीवन काल में ही बंटवारा कर दिए, जिसका वर्तमान में ऑनलाइन पंजी 2 में सभी के नाम से विभिन्न जमाबंदी कायम है, जिसकी विवरणी निम्न प्रकार है. उक्त भूमि पर जमाबंदी रैयतों का निर्विवाद 70 वर्षों से दखल कब्जा है. वर्तमान में यह रैयत के नाम से लगान रसीद निर्गत होते आ रहा है एवं 2021-22 तक लगान भुगतान किया गया. Then he says, what is the position in register 2 in the next page? That
No,
these are
Avidak
the,
Shri Shyam Sundar Dokania.
and I have purchased it from all the persons whose name is already recorded in the register 2, and that too by register deed. So where is the impediment now? And this is during the pendency of the writ petition. Now, why they?
No, was the impediment, so far that is concerned. If I gather from
So therefore, according to you, as per the order of the Deputy Commissioner, he has to proceed in as per Act.
yes, of course.
So merely because the name of the petitioner or name of this or this particular area has been included in some prohibited list, that will
Yeah,
not be an impediment.
NGTRS.
Yes, then that should not be an impediment, because NGDRS is not a concept under the Act. Is it a concept under the Act? No.
Certainly no.
It is not a concept
But
under
it's-
that.
it's
So he has passed an order that you have to make all inquiry. So therefore, merely because the name of this property comes in this NGDRS, that should not be a reason to refuse mutation.
Why we are concerned with that? I'm
No,
explaining.
no, I'm talking about your order only. The Deputy Commissioner has said that do the necessary inquiry.
Yes, yes.
Until the necessary inquiry is done,
Yeah.
there will be status quo. Fair enough.
Yes.
Right? So the necessary inquiry has to have a logical
No,
end.
No, what happens?
On the last date, the other counsel, you were not there, right?
My
Yes. He said that he will seek instruction as to whether any 4H proceeding has been initiated or not.
Yes.
No such proceeding has been initiated. They are in possession of the property. Why don't you go and file your title suit and get it declared? You can't do this.
Manas, kindly listen.
And we can see what is happening.
Yes, yes.
We can see what is happening in the circle. If that is the only reason for rejection, it's something very serious.
Something serious, Manas, is that
Why should we relegate him to appeal when everything is in his favor? But still you do not grant it.
only one thing I will submit, Madam, that now the prevailing circumstances, what happens that for the requirement of registration of land, Madam, mutation is necessary. Now, in many scams, Madam, we have seen.
Is it a scam? Please don't talk about scam. If it is a scam, you just tell us that it is a scam. We will stay our hands out.
It is recorded as Gair Awad in the record of right, Madam.
That is the only thing.
Yes.
You go and declare your title. You get injunction. You will get injunction for further transfer. Will you get or you will not get? Go and get injunction. वहाँ एक तो बोर्ड लगा दीजिए सरकारी जमीन. Right? Nobody will buy that property. Go and get injunction. They will not be able to transfer better title than what they have. Give me some reason. You see, the circle officer is passing an order that it is, since it is kept in NGDRS, therefore he will not do it. And on the other hand, the Deputy Commissioner passes an order that till the necessary inquiry is done with respect to the property, till then he will not pass an order. So you do the necessary and complete it.
So, the part of the circle officer, everything has been done, order has been passed. Madam.
So you show that
so
receipt,
the-
everything has been done. You have done all the necessary inquiry. This is the order 29/7/22 is the necessary inquiry pursuant to the order of the Deputy Commissioner. Where is the order of the Deputy Commissioner? What is the date?
That is, my lords, Annexure 7, page 67.
Annexure 7, right?
Page 67.
This happened in 18/5/2016.
My lord.
Now with respect to the same property, he passes an order. This is miscellaneous. Another miscellaneous case has been
Another.
instituted. Why?
This was for removal of the name from prohibited list. This was separate, but the same circle officer, he recommends that because everything is in order, therefore please remove it from the NGT. The order impugned here is of the circle officer, which is there in the main writ petition, that is dated.
Now he has completed all the necessary inquiry, and according to him, it should not be retained in NGTRS. So there should not be any impediment in passing the order.
But it is merely a recommendation by the circle
What
of-
recommendation?
of the circle officer.
Deputy
to the
Commissioner will have another document.
No. As per the NGTRS scheme, it is the Deputy Commissioner who can release the land from the prohibited list.
So why will
It
he
is
not
merely a
release it?
recommendation by the circle
That's
officer
right.
to the Deputy Commissioner
That's right.
to release the land. So
Yes.
unless an order is passed by the Deputy Commissioner releasing the land,
he has himself passed an order that after necessary inquiry it should be sent.
Yes, that I made.
Yes.
But CO has said to the Deputy Commissioner that इनका जमीन NGDRS से रिलीज
आप
किया
ऑर्डर करा के लाइए ना, सीईओ ने भेजा है 2022 को, 2024 हो गया, किस लिए वेट कर रहे हैं, किसका वेट कर रहे हैं? डेप्यूटी कमिश्नर इज वेटिंग फॉर whom?
Formally, an application has to be made by the tenant to the Deputy Commissioner to get
Yes,
the land
you see,
registered.
whatever this application was filed, the circle officer has recommended to the deputy commissioner. Where is that order?
We shall pass.
You pass the order and bring it here.
Okay. I will pass.
यहाँ से घूमने के लिए नहीं भेजेंगे आपके पास, और क्या क्या आप लोग करेंगे वहाँ पर?
जी.
यही तो कहानी है सर्कल का. एप्लीकेशन भी नहीं लेते बिना पैसा दिए, रेंट भी नहीं लेते बिना पैसा दिए. रेंट आदमी देने जाए तो उसके लिए भी पैसा चाहिए कि आप रेंट दे रहे हैं तो हमको पैसा दीजिए तो हम रेंट एक्सेप्ट कर लेंगे. ऐसा सुने कई दुनिया में. सही है ना? आप तो सिविल के प्रैक्टिशनर हैं, आपको पता है.
So, my lord, I won't comment anything. But so far the records of the case is concerned, I'm writing to the Deputy Commissioner.
Yes, now if the recommendation has come, this in view of this order dated 29/7/22 forwarded by the circle officer, appropriate order be passed on their application and you just file a supplementary counter affidavit here.
Let an observation be made in that.
I will. The learned counsel for the parties are present. The matter was directed to be posted today so that the respondents could seek instructions in the matter. Today, the counsel for the petition respondent has submitted that as per order dated 18/5/2016, within bracket Annexure 7, the Deputy Commissioner had directed the Circle Officer Dhanbad that unless the required inquiry is over with respect to the property involved in the present is done by the circle officer with respect to the property involved in the present case, necessary mutation be not done. यही है, यही है Annexure 7 में. The learned counsel submits that the petitioner had approached for the purposes of deletion of the property involved in the present case from the list of
NGDRS.
from the list, namely NGDRS.
List prepared under NGDRS.
Page 5 I have given
List
complete.
prepared under NGDRS.
National Generic Document Registration System. Page 5 of
Page
supplement.
5.
Subclause 4.
Yes. NGDRS within bracket National Generic Document Registration System. Bracket close. Application software. And a recommendation has been made to release the properties of the petition, to delete the name of the properties
release
involved
the
in the
land.
present case, so that appropriate orders be passed in terms of section 4, 5, 6 and 7 of the Bihar Tenants Holding. क्या नाम है पूरा?
Mutation.
Maintenance of
Bihar Tenants Holding Maintenance of Record Act 1973.
ठीक है. The learned counsel submits that the recommendation has been made by the circle officer to the additional collector by letter dated 27/7/2022, and the appropriate order is yet to be passed by the Deputy Commissioner. Right? He submits that he is not sure as to whether the report dated 29/7/2022 has been placed before the Deputy Commissioner by the Additional Collector. Yeah. This has to go to the Deputy Commissioner.
This has to be.
The Learned Counsel submits that appropriate order may be passed so that the final order is passed by the Deputy Commissioner in connection with the properties involved in the present case. At this counsel for the petitioner submits that there are repeated orders passed in the present case which indicate that the property involved in the present case has passed hands through registered sale deeds, and even proceeding under Bihar Public Land Encroachment Act has been decided in favor of the petitioner or in favor of predecessor in their interest. In spite of that, the petitioner is deprived of order of mutation, due to which the petitioner is unable to enjoy the property in accordance with law.
And 6 years have passed here.
And 6 years have passed, the petitioner is running from pillar to post. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that the circle officer has conducted the necessary inquiry and has recommended to the Additional Collector Dhanbad by letter dated 29/7/2022 to remove the properties involved in the said case from NGDRS list so that appropriate orders could be passed in terms of the provisions of the aforesaid Act of 1973. It is not clear from the records as to whether the said report has been placed before the Deputy Commissioner Dhanbad by the Additional Collector Dhanbad. However, the Deputy Commissioner Dhanbad is directed to pass an appropriate order pursuant to the report dated 29/7/2022, annexed as Annexure 9 to the second supplementary affidavit filed on behalf of the petitioner dated 30/8/2022, and pass appropriate order in accordance with law and appropriate reasoned order in accordance with law and place the same before this court by filing a supplementary counter affidavit. In case the said report has not been placed before the Deputy Commissioner Dhanbad, the respondent number 4 is directed to immediately place the same before the Deputy Commissioner Dhanbad along with all the connected documents. The needful be done within a period of 15 days.
15 days.
कम है, 1 महीना,
4 वीक दे दीजिए।
4, तो आपको टाइम दे दें, आप लगाइए यहाँ। By 16th August,
हाँ।
आज़ादी के बाद थोड़ा सा आप लोग बिजी रहेंगे। The necessary
नहीं,
affidavit
जो
will be
भी-
filed by 20th
Whatever.
of August,
20th.
20 August,
हाँ, ठीक है।
by 20th of August 2020.
बोले-
And
In both the cases.
264, Your Lordship, it is third supplementary affidavit. Instead of second supplementary
नहीं?
affidavit, in that it is third.
264 में थर्ड सप्लीमेंट्री affidavit। ऐसा नहीं तंग करिए।
नहीं, हम लोग खत्म करने की टेंशन।
एफिडेविट फाइल करना है 20 अगस्त तक, इसको 22 को रखा है, पोस्ट ऑन 22 इन सप्लीमेंट्री कॉजेस। ये जजमेंट कॉल
For
करिए।
judgment, item 1, WPL 4378 of 2019 along with item 2.
WPL 4378 of 2019 is allowed, and WPL 924 of 2022 is dismissed. Yeah, for the workman. Yesterday, day before yesterday, when this case was adjourned, I was informed that the TDS amount has not been given by you.
But she has applied for Form 10 application. He has made subsequently. I have
What
already informed him.
application?
He has made an application because I will not
What
be able to
application
communicate
is
him.
required for that?
But I have provided him the entire information. He said that will be done. That will be done within a day or two.
If the petition, if the company is subjected to any kind of penalty, you will
He
have
will
to pay with penalty.
My lord. Because on the date of final argument also it has been conveyed to the client also, as it was.
This is not being fair. But I am absolutely clueless as to why appropriate evidence was not led.
That is the mistake that has been committed by him. That is the only thing.
There is much more. Anyway. The order will be uploaded by the evening today.
From daily list for final disposal, item 1, WPC 3728 of 2010.
Yes, there are three orders of the court which I would like to refer. In the first round of litigation, when the society opposed this on the court members for liquidation of the amounts of the proceeds of the fixed deposits and two saving accounts. What was the order passed by the court? I am still on the point that that order has not been yet fully carried out. And therefore, in this writ petition, two orders were passed by the by this Honorable Court. Kindly have a pleasure, First, the first order, page 33. WPC number 1543/2011. What for we have approached this court? Prayer has been quoted, for direction upon the respondents to forthwith release, pay the up-to-date maturity amount as against the investment made in fixed deposit scheme at Bokaro Steel Central Branch by its ADR number such and such, its initial value of such and such respectively, which was refused to be renewed. Kindly mark, this is the important. Refused to be renewed. So that was the circumstance we had come. First, second, after 21/34, and accordingly to renew the same with retrospective effect till the date of its liquidation and pay the entire amount, which comes to about 2 crores 21 lakhs 29,340, so and so. Further to direct
This, which was under, what was under liquidation? This society?
the amount, the fixed deposit which proceeds by
Okay.
liquidation, was I am saying that was
Liquidation
not
of that proceeds, that
Proceeds.
fixed deposit.
grateful.
I was just
And
wondering if the
and
petitioner
saving
is under
accounts
liquidation.
proceeds. So, in a situation where the society, this Bokaro Steel Society, had invested the money, the bank is a trustee of the amount, and they are a cooperative bank, registered under the statutory provisions, having the RBI license. They were neither renewing the same nor paying
Is there any direction to renew?
Yes, so kindly see this, what has happened. Kindly see paragraph 13 below now, finally. No, finally they allowed that you pay with up-to-date interest. That was the order. But paragraph 13 is important because I don't want to trouble you, Lordship, to take all back. What was the below finding of the court? Paragraph 37. Page 37.
Yes.
Because this I am referring because having to be answered in counter affidavit. It is well settled that legal position of the banker in connection with the fixed deposit is an debtor, and banker constitute to be debtor even though the period fixed for the deposit has expired. So this renewal etc. goes because till the last date of payment you have to pay the interest. This is what the crux of the matter is. Renewed, not renewed. You have not renewed. You have to pay the interest till the last date of payment. This is what my submission
What is
is.
the date on which the
I'll पूरा डाटा है वो चार्ट बना हुआ खाली ये सब दिखा देते हैं then what is direction guidance. I'll come to the facts immediately. Let me finish this one. Only the operative portion पे paragraph 38, page 38, 16. So in this background
नहीं
facts.
आगे पढ़िए ना. The fixed deposit is a complete statutory contract.
Grateful Willis.
What is
Contract
that
between the
statute?
bank.
What is that statute under which it is a contract?
Banking regulation है वो भी आगे लिखा हुआ है सारा discussion है आगे.
आगे पढ़ो.
The period fixed is a complete statutory contract between the bank and the depositor. Contractual obligation cannot be altered or changed. What is required under law is that the banker would obtain a law of authority from the customer before paying back such deposits to a person other than the depositor. In the instant case, once the petitioner, who was the depositor, issues the check to the members to receive, will amount to conferring the law of the authority on the bank to honor the check and pay the amount to the beneficiary. What was happening? When we were issuing the check, they were not honoring, paisa nahi, we will not do it. Neither we will pay nor will honor the check. So in this level, we have approached this court. Then was next, in Delhi Clause General Mills versus so-and-so, the year 1955 Supreme Court, the Supreme Court observed that banking transaction, the following rules are now well settled. The obligation of the bank to pay the check of the customer and that same can be collected from the branch at which they keeps his account. The only condition on which the bank can refuse when the police has seized the money in the bank under section 102 so-and-so, under subsection 3 of the Income Tax Act, which is not the issue in the present case. In case the banks are permitted to dishonor their commitments by adopting such subterfuge, the entire commercial and business transaction will come to an rending halt. The principle that has been reiterated in the large number of bank guarantee cases by the Honorable Supreme Court, the only exception is case of fraud and the egregious nature committed by the beneficiary. Considering the aforesaid facts and survey of the case, this writ petition is allowed with the direction to the respondent bank to forthwith determine the up-to-date maturity value, kindly appreciate it, with interest, as against the investment made in fixed deposits scheme at Bokaro Steel City by the FDR as per the details in paragraph 1 that I have already placed below the judgment. The checks to be presented by the members of the society and further activate the SB account number 1 and 2 pertaining to the Provident Fund, employee of the society, and allow the operation to be doubled in the so-and-so. So, the writ petition was allowed in terms that you have to calculate the up-to-date interest, pay it with respect to SB account, you activate it, you honor the check. Now, after this
So
order,
you wanted this fixed deposit amount to be credited in your SB account.
grateful refund payment, the maturity value should be paid to the society. That was the crux of the grievance. Because they were neither renewing nor honoring the check nor activating, total silence on their part as if that this money belongs to them and they have digested it. In that compelling we approached Mulos. Now what happened, Mulos? After this order was passed, they were not honoring the same, we filed a contempt petition. In a contempt petition, Mulos, kindly see the annexure. What is
Not
that?
honoring the same means they retained the entire amount.
Entire amount. No compliance with the High Court order. Then, when we filed a contempt petition, they came out with one affidavit, that is page 5,
What
annexure
is
7.
annexure 4?
Annexure 4 notes.
These
Annexure
are
4 is
demand
check.
drafts.
In partial payment they made after the contempt petition. This is annexure 4 is a check, photocopy of the check that they paid. Now, this entire controversy revolves around this annexure 1 page only. Kindly see this page. That is annexure 6. Everything is clear from this. Page 47. Whole controversy is summarized here. So, when this writ petition was allowed, what is happening? Calculation statement final. As per the court order dated 15/10/8, total amounts comes to 2,29,72,756 as of this date. This
How
has
do
been
you
accepted.
say as per court order? Where is your calculation of this amount?
This नीचे है हुजूर पूरा अलग से चार्ट दिया हुआ है.
आप हमको बताइए कहाँ है?
Annexure 2 और Annexure
चलिए जरा देखते
this is
हैं।
admitted मतलब in their
नहीं नहीं
source.
admitted बाद में। ये वाला fixed deposit है? When did it mature? What is the date of maturity?
Date of maturity. Yes, for that we'll have to turn back to Annexure 2. We have annexed the entire photocopy of the FD also, SBI account also, and this statement.
Annexure 2 दिखा।
Annexure 2. Projected status of the fixed deposit certificate number such and such dated 21/3/98.
नहीं आपका तो फिक्स डिपॉजिट 98 का था
98 का था।
मैच्योरिटी डेट बताइए।
मैच्योरिटी था, जो पहला मैच्योरिटी था वो जो इसमें लिखा हुआ है डेट 95 से 98 का था। ये अमाउंट फिक्स था 33,96,000। अमाउंट फिक्स है जो राइट में जो 21/12/95 को जो फर्स्ट फिक्स डिपॉजिट था इसका
21/12 पहला तो है ये फर्स्ट एफडीआर इज 21,398।
फर्स्ट है जो 21
अच्छा ये वाला 95
लेफ्ट में हुजूर है।
ओके
95 को हुआ 33,96,591 का था। 95 से 98 तक 13.5% इंटरेस्ट था एफडी पर उस समय। फिक्स डिपॉजिट का इंटरेस्ट इतना हुआ, टोटल अमाउंट इतना। उसी तरह से 98 जोड़ा हुआ है।
तो ये फिर
ये 4 तक का जिस समय ये हमारा रिफ्यूज कर दिया रिन्यूअल वगैरह, उस समय तक का ये प्रोजेक्टेड अमाउंट था। ये अमाउंट आ गया एक एफडी का 4 तक का, दूसरा एफडी का, दूसरा
नहीं ये रेट ऑफ इंटरेस्ट ये 13.5
ये लिखा हुआ है उसमें इनका एफडी में, एफडी सर्टिफिकेट में लिखा हुआ है। वो लोग पीछे लगाए होते हमने लेक्चर है।
अच्छा
यही रेट ऑफ इंटरेस्ट था उसमें एफडी पर।
अच्छा 10.5 कैसे आया?
वो वैरी करता है ना, वो जो एफडी का रेट ये लोग का वैरी करता है। जैसे जैसे रेट वैरी कर रहा था एफडी का, गवर्नमेंट ऑफ इंडिया जैसे आरबीआई से रेगुलेशन आता है, इंटरेस्ट वैरी करता है। हम बिल्कुल जो वही लिखे हैं जो इंटरेस्ट वैरी कर रहा था।
नहीं कहाँ है आपका एफडी दिखाइए। वेरी से एफडी
यहाँ है जो लेफ्ट तो पेज 16 में स्टार्ट होता है। फर्स्ट एफडी तो 13.5% इंटरेस्ट है इसमें लिखा हुआ,
दिखाइए।
13.5. But we were more fair enough to calculate the interest even if it was reduced as per the norms. We have not gone for the consistent of 13.5%. एक समय आया था जब 10.5% हो गया तो भी हम लोग जोड़े हैं।
देखिए ये जो रेट ऑफ इंटरेस्ट एफडी में है ना, ये वेरिएबल नहीं होता।
नहीं वो नहीं कर रहे। पहला जो ये इंटरेस्ट था ये एफडी था जो लिखा हुआ 13.5%, वो चूंकि ये पीरियड जिस पीरियड के लिए एफडी था उसके बाद रिन्यू नहीं कर रहे थे। ये जब रिन्यू नहीं कर रहे थे तो जो एप्लीकेबल इंटरेस्ट था उस पर हम अपना कैलकुलेट किए।
आप एनेक्सर 1 सीरीज का पेज नंबर 17 में आए।
पेज नंबर 17 जी
ठीक है।
12.5% एक जगह है।
दिस इज 12/21/12/95 का है एफडी, और दूसरा है आपका एफडी 33/1998 का। 2 एफडी है ना इसमें।
ठीक है
पेज 16 में।
पेज 16 में
हाँ
राइट।
इट इज फॉर 3 इयर्स, फिक्स डिपॉजिट फॉर 3 इयर्स।
जी जी
हाँ उसका बैक साइड में दिस में काइंडली बी रिन्यूड फॉर ए फर्दर पीरियड ऑफ 3 इयर्स
ग्रेटफुल क्लोज।
राइट। उसके बाद आपका ये रिन्यू हो गया शायद कि नहीं हुआ।
हाँ ये तो रिन्यू हो गया ना, 4 के बाद रिन्यूअल बंद हो गया।
ठीक है
4 तक तो रिन्यूअल होता रहा,
4 तक रिन्यूअल होता रहा, 4 के बाद रिन्यूअल बंद हो गया। ठीक है।
अब उसके बाद क्या हुआ जो आज के आगे बहुत सारी बातें हैं। अब ये पेमेंट हमारा जब ऑर्डर हुआ 1 करोड़ रुपया 1,65,00,000 के लोग पेमेंट कर दिए एक पर्टिकुलर डेट पर। ये टोटल कैलकुलेशन जो आया मेरा जो प्रोजेक्टेड था वो था पेज 32 पर देखा जाए। हम 1 बाय 1 हुजूर दिखा देते हैं कहाँ केस है। अभी सेकेंड राउंड ऑफ लिटिगेशन हम लोग हैं, इंटरेस्ट पर अभी हम लोग हैं।
वो हम जान रहे हैं, वो
जी।
इंटरेस्ट का ही कहानी
जी
है।
अब देखा जाए पेज 32 खाली।
इन्होंने आपको क्या रेट ऑफ इंटरेस्ट पे पेमेंट किया?
जो हम लोग क्लेम किए थे उन्होंने एफिडेविट में 2 बार लिखा कि ये बिल्कुल, एक बार लिखा कि 1,55,00,000 होगा, फिर फ्रेश एफिडेविट फाइल किए लेकिन ये कैलकुलेशन पर 2,29,00,000 होगा। दैट एफिडेविट आई विल टेल यू, दे आर फाइल्ड एन एफिडेविट बिफोर दिस कोर्ट
that you are entitled to this amount.
grateful notice this
Still they are not paying.
still not paying. What happened thereafter? They made a part payment, then after 2,29,00,000 they paid on this again kindly come to page 47 if everything will be clear now. this amount has been admitted. I will show the affidavit. Twice, two affidavits there. 229,72,756 was admitted in affidavit. Now, the controversy is that up to February 2008, this was the calculation minutes, 229 so and so. 5/10/2009, this interest comes to rupees such and such, total comes to 268. And on 5/10/2009, they paid 1 crore 63 lakhs. This is the minus. 1 crore 63 lakhs they paid. Then what happened? Upon this calculation, from 5/10/2009 till 18/6/10, the total amounts come to, with interest, comes to rupees this 1 crore 12 lakhs 83,529. Because on 17/6/2010, they paid 53 lakhs 88,129. So rest amount was 58 lakhs 95,040, and this 50,000 is a litigation cost that we have claimed from them. So as per this calculation, we lost because whatever the amount that as on date you are paying, amount is fetching the interest. That is not a static. Now they say what? We have paid the total amount, no interest, rest. This is the crux of the fight. So when we say that in spite of this 2 crore 29 lakhs that we have paid, total amount that is at top has been paid with us. But this interest has not been paid. In this circumstances, what has happened? We file a contempt petition. In contempt, then file an affidavit. Can you see the affidavit? That is annexure. Can you see this page? The supplementary affidavit. On a supplementary affidavit is there. Can you see the first 14, 12, 10. I have the next affidavit that they have filed. Annexure sub with the supplementary affidavit. Dated 14/12/10.
What happened in the contempt?
In
The
this
contempt
context,
was
what has
dropped.
happened? They made a statement at page 6 of this affidavit. This is the so-called they have filed in the contempt. And what they have stated, because there is a case of gold press, they have now filed the affidavit totally contrary to this affidavit, which my respectful submission borders to contempt. That in the first supplementary so-called file, paragraph 6, I am placing page 6 of the affidavit. On behalf of the answering opposite party, it has been stated that in the first round of calculation, the maturity amount of 4 FDR had come to 1 crore 54 lakhs 49,430. Next paragraph. That now the computation of the maturity amount of the various FDR of the society mentioned in the paragraph 1 of the order of the court dated 25/10/2008, that is annexure 3 that I have placed notes, has been completed, and on calculation it has been found that society is entitled to the maturity amount of 2 crores 29 lakhs 72,756, which is the calculation that I have made. It was accepted in entirety. So and so, so and so, so and so. That however, the financial condition of the bank is not such that the entire amount can be paid at once at instance. Hence, the answering respondent has already made a payment of 1 crore 63 lakhs, so and so, so and so, in the form of bank draft to the petitioner. Society and further agrees to pay remaining amount of 66 lakh 72,756 within a period of 8 months from the date of filing of this second supplementary so-called. Would pray before the court to grant further time 8 months to pay remaining amount of rupees so and so. The answering opposite party has very complied the order so and so, so and so. Now on this affidavit, what has happened was, can you see the order passed by the court, page 10. We have filed an IA. They said, because we were not litigating, that well, we are ready to settle the matter of this amount, but our liberty of interest further should be reserved. The court passed an order. This IA has been filed for withdrawing the contempt petition, saying that order has been complied, but petitioner may be given liberty to claim interest in the accordance with law if so advised. Accordingly, this contempt petition is permitted to be withdrawn with aforesaid liberty. Now, my lords, when this, instead of 8 months, they again faced far off. They paid the total amount that that page that I have shown, the calculation chart, this is annexure 6. Plus, in the intervening period, the amount kept on fetching interest. So this 58 lakhs 95,000 is the balance. We made a demand from them that please pay it because it's the money of my members. and you have paid in fraction, amount is kept on fetching interest. The order of the honorable single judge was to pay with up-to-date interest. They did not pay any heed to this loss. Then we filed the writ petition. In this writ petition loss, I only have a pleasure of the first order that was passed at order dated loss 7/12/2022. Order number 7. What was the direction of this court? It has attained finality loss all these successive orders passed by this court in the same proceeding has not been questioned by them. Heard and counsel for the parties. When counsel for the petitioner, Mr. So-and-so has submitted, petitioner Bokaro Steel Employee Limited has preferred this writ petition against the DC cum administrator Hazaribagh so-and-so, so-and-so. The managing director Hazaribagh so-and-so, so-and-so has merged now in Jharkhand State Cooperative Bank, Karachi, with effect from 1/4/17. As such, office may be directed to implement the Jharkhand State Cooperative Bank Limited as order number 4. Dispute is between the Bokaro Steel Employee Cooperative House Construction Society Limited, a society registered with the Society Registration Act, and the Cooperative Bank with regard to payment of dues, in which the judgment passed by the coordinate bench of this court pronounced on 15/10/8 in WPC number so-and-so, whereby the coordinate bench has directed to determine the up-to-date maturity value with interest as against the investment made in fixed deposit scheme at Bokaro Steel City, and thereafter petitioner has submitted that on 25/10/2008 a sum of rupees 2,29,72,756 was deposited. The interest up to 659 is 38,35,870. The total 2,68 lakhs. The bank has paid initial check 510,9 of 1,63 lakhs. The due remain after deducting 2,68 lakhs to be 1,05 lakhs 8,626. The interest charged from 510,9 to 18,16 is 7,74,000. Then total comes to 1,12 lakhs. Thereafter, bank paid a check to the tune of rupees 53 lakhs so. Then total remaining amount comes to rupees 58 lakhs 98,400. Further litigation cost of 50,000. The net amount payable by the Hazaribagh Cooperative Bank comes to rupees 59 lakhs 45,400. Office is directed to implement the Jharkhand State Cooperative Bank as party respondent number 4. The Chief Executive Officer of the Jharkhand State Cooperative Bank is directed to file detailed statement of fact along with interest up to date. Kindly appreciate my note. Before this court by 13/12/12, let the matter appear in so-and-so, and counsel Mr. So-and-so directed to communicate the order so-and-so for the compliance of the order, failing which salary of the Chief Executive Officer so-and-so serving next so-and-so. Nominals. Thereafter, when the matter was taken up on, kindly see this, order number 8. In order number 8, they have not filed the affidavit, nothing all about. Serious view was taken by this court. And they were saddled with the cost of 25,000 in two circumscribed with two conditions. Kindly have a pleasure, I just placing the prayer portion. Last, order number 8, 23/1/2014. Prayer is allowed subject to payment of 10,000 by the Chief Executive Officer of Jharkhand State Cooperative Bank, Karachi, to the petitioner for the non-compliance with the earlier order of this court. Further, respondent number 4 is directed to comply with the earlier order within a period of 10 days. Submit the said report, failing which he will be also paid 25,000 to the petitioner. I have come out with the reply to the counter affidavit, wherein they have filed a statement calculating the amount of this 55 lakhs on simple interest. As per them, that amount comes to rupees. I have the pleasure of the counter affidavit which was filed in compliance with this order.
Was there any condition in the FD that it will be compounded?
Plus, that will continue as it is. If they have refused, I have not refused. I'll come to the judgment of the Supreme Court. 2 judgments I have brought. It is partly covered. I'll show the lordship that judgments. It was initial. Had it been the case that we have refused to renewal, etc.
You see, in your earlier round of writ petition, you had sought for a prayer that they should be directed to renew the fixed deposit.
No, renew and liquidate also.
That's
Can you
it.
see this?
Renew and just a moment.
Lordship.
So the order of renewal was not passed.
Not necessary. Why? There is order of up-to-date interest payment.
Up to date interest as per the norms, certainly.
Grateful.
If the fixed deposit is not renewed,
Grateful.
then the rate of interest is different from the fixed deposit.
Who has
rate
not
of
renewed?
interest.
They cannot take a
So
benefit of their
therefore-
own fault.
That's right. But the point is that in the writ order, there was no direction to renew.
Their formulas, I am saying. What is the order?
Therefore,
Paragraph 13.
the question of making payment of rate of interest as per the fixed deposit
Yes.
rate would arise only if there was an order of renewal with retrospective date also.
Plus, I vote on those.
There is no
There-
such
I
order.
vote on those. No, that is implied in operative portion. Can you see the operative portion again?
Implied तो बहुत मुश्किल
No,
है
no.
बोलना।
Operative में है ना, क्या लिखा हुआ देखिए.
पढ़िए।
What is written in the operative portion? Can you see the operative portion? Considering the aforesaid facts and circumstances of the case, this writ petition is allowed with a direction to the respondent bank to forthwith determine the up-to-date maturity value with interest as against the investment made in fixed deposit scheme at Bokaro Steel City by the FDR as per details given in paragraph 1 of the judgment on rejections. So up-to-date interest. For what? FDR.
Rate of interest भी बोले क्या?
Rate
FDR
of
के
interest.
rate of interest.
Plus, therefore, paragraph 13. There is a reason for paragraph 13. Can you see this paragraph 13? It is well settled that the legal position of the banker in connection with the fixed deposit is one of the debtor, and the banker continue to be a debtor even though the period of fixed for the deposit is expired. So, plus that contract was
No, that contract is there.
Contract
but
is
the
for-
point is that the rate of interest will vary.
No.
Because there is a reason for it that under the provisions of fixed deposit,
Yes.
right, that money cannot be utilized by the petitioner
Yes.
under any circumstances.
Money-
But that particular lock-in period has to be
Because
there.
money remains with whom?
Wherever it is, their norm says that once the period of fixed deposit is over, and if it is not renewed, then you are entitled for a different rate of interest.
That,
and
renewal,
not the,
that circular came in 2016
No, no.
by the RBI.
No.
They have been closed.
we do not know when.
I will come to that, Mullers. I have a lot of set.
So therefore, this particular case requires a lot of adjudication on the rate
Very
of
good,
interest.
Mullers.
You go and file your suit.
No, because I am on
Why
the
no?
position. These two orders.
Why no?
These
What
two
was the
orders.
rate of interest?
Mullers,
What
this-
was the circular of the
Mullers, these two orders
RBI?
passed in this writ petition has been attained finality. This argument, this order number 6, 7, and 8.
There is no direction to renew the rate.
So
of
there is direction, Mullers, to file up-to-date calculation interest.
Yes, they have done calculation of
They
rate
have
of
done
interest.
what? So, Mullers, what I am saying, this annexure 3.
And you see, you yourself have made a calculation by reducing the rate of interest to 10%. How does
No.
a variable rate of interest is
Mullers,
applicable?
FD rate varies. As in
FD
today is
rate
6%.
does not vary.
Mullers, FD rate varies.
No.
Suppose,
No.
Mullers,
Today, if you fix an amount at a rate of 6%,
correct?
you will get 6% only.
6%.
Even
Till-
if the rate of interest decreases or increases in the meantime.
Mullers, what is my experience?
That is why just experience से नहीं चलता है सर.
नहीं
You
ना, हम
just
तो
have-
FD जो मेरा है ना बैंक
अरे
में,
आप सुनिए तो सही.
क्या करता हूँ लोग,
आप-
हम यदि नहीं जाते रिन्यू करने
नहीं,
तो जो
नहीं।
रेट होता है उसी पर रिन्यू कर देता ऑटोमेटिक.
आप जरा देखिए, रादर वो अगर ऑटोमेटिक रिन्यू कर देते हैं तो
हाँ।
यू कैन जस्ट चार्ज देम कि आप कैसे मेरा एफडी बिना एप्लीकेशन के रिन्यू कर दिए. दे आर
Yes.
नॉट सपोज टू.
Then what is their loss? I could have got 13.5%. If not,
there is a
they are in
you
beneficial position.
you देखिए ये कोई यहाँ पे इक्विटी नहीं चल रहा है, यहाँ पे
Sir,
सीधा सीधी
loss-
कैलकुलेशन चल रहा है. आप पेज नंबर 10 में आइए इनके एफिडेविट के, ठीक है. ये सिंपल सा कैलकुलेशन है, इसमें कुछ इतना एजिटेटेड होने की कोई बात
नहीं हुजूर, वो तो
You
they
come
are
to
not
page
compliant
number-
with court's
just a
order.
moment.
They will
तो
take benefit of
आप
that.
कंटेम्प्ट विड्रॉ नहीं करना चाहिए था आपको, पैसा
Contempt
लेके विड्रॉ
withdrawal,
करना
no.
चाहिए.
It was understanding that they will. They
So
are-
therefore you were claiming more interest. So there was a dispute. Content पे आपको
It was
एक
not more
observation
interest,
मिली.
up to date interest. There
We
is
do not
difference
know.
between more interest and up to
Up
date
to
interest.
date interest. What would be the rate of interest? ऐसा तो कोई quantify नहीं किया है ना.
नहीं, plus therefore the whole order has
You
to be
should not
read.
have withdrawn the
This prayer,
contempt application.
this order of the Mullers annexure 3.
You come to page number 10 of their calculation which they have furnished. उसी से clear है.
ये तो हुजूर सिंपल इंटरेस्ट जोड़ दिया उसके बाद.
Simple interest नहीं. आप जरा देखिए तो
हम
सही.
देखे हुजूर इसको.
क्या देखिए आप
हम
कुछ नहीं
देखे
देखिए.
इसको हम देखे.
आप
ये
पेज नंबर
चार के
10
बाद जो
एक
जोड़ रहे
सेकेंड.
हैं.
अरे भाई हमको भी
3.5%
हमको नहीं सुनिएगा तो हम ऑर्डर जो करेंगे तो गलत हो रहा ऑर्डर हो जाएगा.
देखा
सीधे-
जाए 3.5% जोड़े.
सुनिए ना एक सेकेंड. ये जो 13.5% है ना
हाँ।
ऊपर, ये सब सिंपल इंटरेस्ट है.
नहीं ना है हुजूर, वो
अरे
वो
भैया।
देखा जाए ना क्या 4 के बाद वाला जो है।
आप अपना एफडी में देखिए कंपाउंड इंटरेस्ट है कि सिंपल इंटरेस्ट है।
कौन सा?
एफडी में ही लिखा रहता है कंपाउंडिंग है कि
कंपाउंड इंटरेस्ट का तो कोई इशू ही नहीं हुजूर, खाली रेट ऑफ इंटरेस्ट का है बस।
तो आप बोलते हैं कि सिंपल इंटरेस्ट जोड़ दिए हैं।
ये है ना 3.5%।
3.5
ये एफडी का
सेविंग,
खाली लड़ाई है कि
FD
एफडी
का
रेट
नहीं
होगा
है।
कि सिंपल रेट होगा।
ये एसबी अकाउंट का रेट होगा, सेविंग बैंक का।
हाउ विल
ऐसा ही है ही।
no this order of the single judge, I'll read it again, will scroll up, then kindly see this order, what is the intent of this order?
नहीं वो ठीक है, वो तो आप कंटेंट फाइल कर दिए, उसके बाद आप
Plus this
copy
order,
करा दिए।
that judgment of Supreme Court I will cite minutes, I'll give you 1 day time.
आप
Supreme
one
Court
day
says
time आपको सुन
no,
रहे आधा घंटा से वो आपको
not
one day time
but this
चाहिए।
question has come for the first time.
What do you mean?
According
This
to me,
is how
was
it
the
is
order,
calculated.
this
You are-
order will be
You are
order will
not
carry
aware,
till
आप अपने बैंकर से पूछ लीजिए कि
हम लोग पूछ लेते
मेच्योरिटी
हैं।
अगर हो जाता है और अगर रिन्यू नहीं होता है तो क्या रेट ऑफ
रिन्यू नहीं होता है हमारे तरफ से तब ना,
देखिए,
यदि वो रिफ्यूज कर
you
देंगे
had-
तब क्या होगा?
You had filed a writ petition before this court
हाँ।
directing them to renew your fixed deposit.
Therefore, the
That
court said
prayer
what?
was no, that prayer was not granted.
No, Mulos, their prayer was granted. Why granted? Can you say again? Whole order I will read, Mulos. Then
We have read
it is clear from the order, from the whole order. That
We
was
have
granted in
read.
explicit
Let's
term.
move forward.
Can you see, Mulos, the order? Can you see the whole tenor of the order?
तो
What
फिर
is the
तो
spirit
आपको
of the
रिन्यू
order?
कराते ना वो।
Not they said that पैसा दे ही नहीं रहा था, तो कंटेंट पे 2 बार हाजिरी हुआ, डीसी का तब पैसा दिया, रिन्यूअल कहाँ सवाल है? Can you see the whole circumstance? When the
देखिए,
postal
ऐसा है
appearance
ना,
was
कोर्ट में कब क्या हुआ उसका उसके तो हम विटनेस
नहीं,
है
नहीं, उस order में
हम
है ना
तो
वो।
ऑर्डर के अलावा कुछ नहीं
नहीं,
जानते।
वो क्या हो तो ऑर्डर में है ना, सारा उसका सीक्वेंस लगा हुआ है, हम ऑर्डर लगाए हैं। In what manner it was realized, court has to go up to the extent of making a personal appearance to deputy commissioner or administrator. Warrant of arrest was issued. Then they appeared before the court and then it was paid over. See the most
आपको
circumstance.
उनका कन्विक्शन करा देना चाहिए था, आपका कंटेंट पिटीशन
वो जो आज तक झारखंड कोर्ट में हुआ है,
हुआ
conviction।
कि नहीं हुआ है, आप रहेंगे तो नहीं होगा।
नहीं ना
ऐसा
होगा
नहीं
हुजूर।
है।
मेरा शोकोज कनेक्शन
वो आज तक नहीं हुआ है हुजूर। एक वीडियो भी कहीं जेल नहीं गया आज तक कंटेम्प्ट हमारे हाई कोर्ट से। इसलिए तो हुजूर यहाँ एग्जीक्यूटिव सुनता नहीं हम लोग का बात। एक आध केस में हुजूर बांध दिया जाएगा ना, कोई वीडियो को भी हाई कोर्ट का हुजूर मैजिस्ट्री कहीं और चला जाएगा। जो मेरा एक्सपीरियंस है हुजूर 24 साल का, आता है हुजूर, सो कुछ होता है, माफी मिल जाता है, चला जाता है, फिर वही कहानी करता है।
वी बिलीव इन
आपको झारखंड हाईकोर्ट का इतिहास नहीं मालूम,
अब हुजूर इतिहास तो 24 साल का मेरा है, 22 साल का
हाँ,
यहाँ
इसके
पे।
बियॉन्ड तो नहीं जानते
उसके
ना।
बाद हमको हुजूर
उसके
आइडिया नहीं,
beyond
हुजूर को
थोड़ा
थोड़ा
बहुत
हमसे
हम लोग
ज्यादा
को
चूंकि
मालूम।
लेंथ था प्रैक्टिस का। बट हुजूर ये ऑर्डर हम पूरा हुजूर प्लेस करना चाहते हैं, इसका स्पिरिट देख ले रहा है क्या है। इट इज वेरी हार्श ऑर्डर।
I'm quite-
Their lordship has said, up to date maturity means what? What maturity? Simple interest. Maturity means
सिंपल इंटरेस्ट तो 13.5% भी है,
तो
वो कंपाउंडिंग नहीं होता है।
इंटरेस्ट पर जाएगा मेरा, वही ना रहेगा अप टू डेट। हुजूर क्या है, एक होता है एफडी रेट ऑफ इंटरेस्ट ओवर द एफडी इन्वेस्टमेंट एंड रेट ऑफ इंटरेस्ट ऑन द एसबी अकाउंट इन्वेस्टमेंट। द डिस्प्यूट इज they agrees that they file in calculation of 33 lakhs. They say that we are payable, this amount of 33 lakhs is payable. We are saying not 33 lakhs because they have the only dispute involves whether it will be 3.5% or the calculation that we have filed with the help of the chartered accountant. That is the rate of interest which is applicable on fixed deposit.
And you see,
9.25%.
your grievance was twofold.
Grateful.
One was that the FD was not being matured,
No, not-
was not being renewed, and the second grievance was that your checks were not being encashed.
According to saving accounts. In saving
According
account,
to saving accounts, it was not being encashed
Honored.
because of the money was not there, right? So according to you, this money of FD should have been credited in the SB account
not
such
necessarily.
that the checks could be encashed.
In saving account, there was a money. Saving account was an empty account. More than 50,000 rupees was lying there. Even that was not honored. My saving account was carrying certain money. Even the check issued as against that account was not honored by them. Kindly see them as conduct of a bank. They cannot be take benefit of their own fault. They cannot be granted premium for the fault that they have committed. On the contrary, they will lost all that inference of adverse is in my favor. It will amount granting them undue loss benefit of their own fault if their interpretation is being given action to the court. Kindly see the circumstances. They were so much so deep. And see the audacity, what kind of affidavit they have filed. Kindly see. Still I am showing they are under
आप
the
अपना
contempt.
राइट दिखाइए कि आपको क्या रेट ऑफ इंटरेस्ट मिलेगा। इस तरह के कंडक्ट से कोई
Correct.
फर्क नहीं पड़ता है,
Correct.
ठीक
Kindly see the
है।
judgment.
लॉ दिखाइए और पूरा इंटरेस्ट लेके जाइए।
हाँ ठीक है,
हाँ,
तो
law
हमको
दिखाइए।
हमको 2-3 जजमेंट लाए
लॉ
हैं।
दिखाइए, सर्कुलर दिखाइए, सब दिखाइए।
तो मुझे थोड़ा
रीट
सा
में
और समय
जुरिस्डिक्शन
दीजिए,
चाहिए,
और थोड़ा
रीट
मेहनत करते
जुरिस्डिक्शन
हैं।
में ऑर्डर चाहिए कि रेट ऑफ इंटरेस्ट हम क्वांटिफाई कर दें, तो आप हमको मटेरियल दीजिए।
हम सिर्फ इतना ही, पर हुजूर अप टू
कुछ
डेट
नहीं।
मैच्योरिटी का मतलब क्या
अप टू डेट मेच्योर, आप हमको सर्कुलर दिखाइए, आरबीआई का सर्कुलर दिखाइए, बैंक का सर्कुलर दिखाइए कि भाई अगर मान लीजिए एफडी नहीं रिन्यू होता है, यू आर एंटाइटल्ड टू द सेम रेट ऑफ इंटरेस्ट।
Because I will try to
I
source
will
out-
pass, I will quantify, calculate myself and pass a
That
direction
power
to
is always to my lord's power is not-
क्वांटिफाई कराइए। आपको
वो
सूट
हुजूर
चाहिए,
को power
आपको
बहुत
मनी
कुछ
सूट
है।
का ऑर्डर करो।
हमारा ये हुजूर समझदारी है, अकॉर्डिंग टू माय जजमेंट हम देंगे हुजूर को। The order which has attained
जजमेंट लेके
finality,
आइए ना, फिर जजमेंट लेके आना चाहिए,
जजमेंट लाए हुजूर हमें।
लाइए
हम देखते
कि
हैं।
फिक्स डिपॉजिट
जरा
की
सा
मेच्योरिटी होने के
थोड़ा
बाद
सा
भी जो
हुजूर-
है,
थोड़ा सा हुजूर फॉर्मुलेट कर लेते हैं क्या करना
नहीं
चाहते हैं।
हमको हमको जब से फाइल खोले हमको तब से पता है कि आप यहीं पे पहुंचने वाले हैं।
हुजूर तो पढ़ के आए होंगे, हमको पता है।
नहीं, इसके लिए पढ़ने की जरूरत नहीं है,
नहीं, नहीं,
ये बैंकिंग
हम क्या कह रहे हैं हुजूर,
पता है।
मेरा एक ही आर्गुमेंट है। Whatever order has been filed, passed by the honorable single judge, Annexure 3, that has attained finality. And that last portion says up to date maturity value. Maturity value means what? FDR. That's mentioned. That does not talks of SB account rate. Because the prayer has been quoted and the direction after due discussion is this. Because whatever is the finding and discussion, that is final. They have not challenged that. Rightly, wrongly, that is the discussion, that is the finding. That has attained finality, that has to be carried out as it is. That judgment I can give to your lordship, that once any order is passed, even if contempt is dismissed, even a second writ petition is maintainable for implementation of that order. Mere dismissal, even dismissal of contempt petition will not dilute the force of that order which has attained finality. Rather, it is the duty cast upon the Milos to see that that order is Milos carried out in letter and spirit. My respectful submission is that letter and spirit of that order is that the entire amount that was invested in FDR should be calculated with up-to-date maturity value. Up-to-date maturity value means not 2004 when the order was passed. Order was passed in 2008. Now they have filed this calculation, what Milos can see. They are calculating from 2004 onward 3.5%. That as per the order of the honorable single judge which was passed and attained finally.
देखिए रिपीट करने से तो कोई
नहीं रिपीट
improve नहीं
हो
हो रहा है।
हम तो वही क्लैरिफाई कर रहे हैं।
हम आपका कैलकुलेशन खोल के बैठे हुए हैं, इसमें कैलकुलेशन में गलती है आपके अनुसार कि 3.5% नहीं होना चाहिए, 13.5%।
नहीं 30 नहीं होना चाहिए।
कितना
जो
होना
अभी जो कैलकुलेशन दिए जो अप टू डेट जो 2008 के बाद वाला जो मेरा जो पेमेंट है जो लास्ट पेमेंट हुआ 2010 में,
हाँ।
10 के बाद का जो कैलकुलेशन वो देखा जाए पेज 14 पर है मेरा रिजल्ट क्या हम दिए हैं,
क्या होना चाहिए?
वो है 9.25
नहीं हो सकता ना।
9, 8,
एफडी का
7.5।
कंसेप्ट ही यही होता है, इट इज नॉट अ वेरिएबल रेट ऑफ इंटरेस्ट।
FD का रेट
दैट इज
vary कर रहा है ना
नहीं
लोगों का।
करता। देखिए इसीलिए इन्होंने जब जब आपका रिन्यू हुआ है आपका फिक्स रेट ऑफ इंटरेस्ट इन्होंने दिया है।
तो जो
There is no way. नहीं पड़ता है भैया, थोड़ा जाके नहीं बदलता है, आपको नहीं पता है। अगर एक बार आपने एफडी कर दिया, अगर मान लीजिए 8% पे कर दिया, तो वो एफडी के लिए वही 8%
तो मेरा और हायर अमाउंट हो जा।
बिल्कुल, आप तो गलत क्लेम कर
तो हम
रहे
रिकैलकुलेट कर लेते
हैं।
हैं।
रिकैलकुलेट कर
मतलब देयर इज नो एरर।
नहीं,
if
आपको
law Milos grants me more amount on our pleading Milos, court can always see that whether you're right or wrong. If the legally it can be answered in my favor.
Therefore, legally it cannot be answered in your favor because there was no renewal of fixed deposit.
Milos, therefore I'm
Otherwise, you
saying-
would have got 13.5% and not 9% or 10% or variable rate of
Very good,
interest.
Milos. Then if that
You
is the
are
Milos-
entitled to SB account rate. That is
According to
3.5%.
my respectful submission, that
जजमेंट नहीं मिला आपको इस पर?
नहीं मिलेगा इनको, हम भी खोजे थे।
एक मैं भी permitted.
सर्कुलर है इसमें।
I have an access. I may be permitted, madam.
ये सर्कुलर 2016 का लगाए हैं, प्रोस्पेक्टिव और रेट्रोस्पेक्टिव होगा।
Subject to his permission, madam.
नहीं सर्कुलर हम पढ़ कर रहे हैं, आपका काउंटर हम भी पढ़ देते हैं।
हमको तो मेरा टास्क आप हमको कर दीजिए।
पढ़िए
मैं समझता हूँ। First, my objection would be, madam, this is a dispute between two cooperative societies, which comes under section 48 of the Jharkhand Cooperative Society. Here, the alternative remedy to approach the registrar. As it fell from your lordship, it requires a lot of adjudication, which this honorable court under Article 226 may not go into. Secondly, madam, if your lordship comes to my so-called matter,
Petitioner is also a cooperative society.
Yes, sir.
Yes.
It's a cooperative society. I was a cooperative society.
So it is a dispute between two
Two cooperative
So
societies.
earlier writ petition was entertained
48.
on the
Yes,
face
it
of their
was
high
entertained,
handedness.
but that does not say that I cannot make an objection to that.
First objection is section 48.
No, madam. Now you also may come to my so-called first so-called method. Then I have next section A method, which was the interlocutory application filed by them in the contempt application. I will read only one paragraph. Madam.
Para number, page number.
My so-called page 8, but it starts from page 8. I'll read from
Yes, page 8.
I read from page 9, para 5. That in the second supplementary so-called filed on behalf of the managing director of the bank, it has been stated that the calculation of the petitioner has been found to be entitled to 2 crore 29 lakhs and odd as the maturity amount for the FDR of the society of the bank. That out of this amount, 1 crore 63 lakhs has already been paid to the society. That in the second supplementary affidavit, there is undertaking given by the MD of the bank that he would be paying the rest amount of rupees 66 lakhs within a period of 8 months from the date of filing of the second suit. That in view of the stand taken by the managing director of the bank and undertaking given by them, the petitioner wants to withdraw the intent contempt application. So unconditionally they withdrew the contempt application, and then again they are agitating. Well, if this amount was
This
known,
much amount has been paid.
229 has been paid.
229 has been paid.
229 has been paid. That is not a
That is an
dispute.
admitted case, madam. So the only dispute is, my lord, as it said from your lordship, after the FDRs are not matured or not renewed, whether FDR rate of interest will be payable or saving bank rate of interest will be payable. We have said that saving bank rate of interest is payable, my lord, and we have next circular, my lord. If your lordship comes to,
You were satisfied with this amount as per
Not
this?
satisfied. I
As
have
per
made a
this-
statement. They have said that therefore the honorable writ contempt court granted me liberty for interest. Plus condition situation देखा जाए, जहाँ 1 रुपया नहीं मिल रहा था, 3 लिटिगेशन के बाद पर्सनल मिल रहा है, ये लोगों ने कहा कि ये जो बाकी पैसा हम तभी देंगे जब आप विड्रॉ कीजिएगा. Kindly appreciate plus the conduct.
There is no such-
आपको विड्रॉ नहीं करना चाहिए था, उसको
Plus kindly
कंटेम्प्ट
see.
करना चाहिए कि हमको डरा रहे हैं.
Well, that is not a
Yes,
sin.
sir.
The party has to explore the remedies properly. Therefore, the writ court granted liberty to claim the interest. That order has also attained finality.
Yes.
Can you see that order of the writ court, the contempt court? They have not challenged that order.
देखिए यहाँ पर हम आपका रेट ऑफ इंटरेस्ट डिटरमाइन करने के लिए
नहीं करने की जरूरत है हुजूर, वो
हम
हाई
नहीं
ऑर्डर में
करेंगे
लिखा हुआ.
और करने का कोई स्कोप नहीं है.
नहीं
आपको
जरूरत
मन
है
है तो
हुजूर.
अपना
अब
48
आप
में
बता देते
जाके
हुजूर क्या है जजमेंट उस पर, क्या कैसे एडजस्ट होगा. प्लस लॉस इज व्हाट.
नहीं
When the
सुनिए आपको
interest-
जजमेंट सीधी पॉइंट यही है कि रेट ऑफ इंटरेस्ट एफडी का रेट ऑफ इंटरेस्ट मिलेगा कि सेविंग बैंक अकाउंट का रेट ऑफ
my lord, if your lordship may reply
दैट इज द
dated-
सोल पॉइंट.
हम उसको आ रहे हैं ना.
हाँ तो जजमेंट दिखाई, कौन सी जजमेंट दिखा रहे हैं?
सबसे पहले तो हुजूर इस पर आ जाए कि यदि रीट कोर्ट का ऑर्डर कंटेम्प्ट डिसमिस हो जाता है तो क्या
नहीं कोई जरूरत नहीं है. हम उस ऑर्डर को भी इंटरप्रेट कर लेंगे. रीड कोर्ट अपने ऑर्डर को इंटरप्रेट कर सकते हैं ना.
कर सकता है, बट नॉट कंट्री टू द फाइंडिंग दैट इज रिकॉर्डेड देयर.
वो I will see the finding as it is recorded.
Then my lordship may permit me to place the whole order.
I have
Because that
read it.
requires.
I have read
Plus,
it.
I have not read the whole order before lordship. Lordship
आप
may
अपना रिटर्न
lordship may
सबमिशन
permit me
फाइल
to place the whole order.
कर. आप अपना रिटर्न सबमिशन फाइल कर दीजिए. हम
Plus,
पढ़ लिए
written
हैं, ऐसे
submission
नहीं
I will
होता
file
इस तरह
minutes,
से.
But probably I am not
इस
able to
तरह
convince
से-
to your lordship
नहीं.
the way that I can
ऐसा
read
नहीं
it
होता.
before
I have read
lordship.
it. I have read it. I read very fast. I am a very fast reader.
Plus, very good.
जितना देर में आप 4 पेज पढ़िएगा, हम उतना देर में 10 पेज पढ़ेंगे.
है ना, तो हुजूर का ठीक है, उसमें तो जब हमको जो अपना स्पीड है वही रहे, उसको बदल तो सकते नहीं है. इसका यही है.
I have read it.
So kindly see this paragraph 3 of that writ order. What has been written by the honorable single judge.
सुनिए क्या रिटर्न है नहीं है, क्या फाइंडिंग है वो पढ़ाइए.
हुजूर फाइंडिंग तो उसका डिस्कस बॉडी जो मेरा केस था उस पर ना फाइंडिंग हुजूर. Law says what? Even in contempt proceeding there is some ambiguity. Then prayer and
Mr.
pleading has to be
Murari,
seen.
There was a prayer seeking renewal of fixed deposit.
And then
Right.
court granted relief up to date interest. Up to date interest
Up to
means
date
what?
interest will be calculated as per law. साथ
per
में
law.
in accordance with law भी तो लिखा हुआ है.
कहाँ? हाँ ठीक है, तो इसमें तो ये भी लिखा हुआ है ना हुजूर. Fourth will determine up to date maturity value. Maturity value comes below in FD only, not in SB account.
No. Maturity value will come with whenever the payment is to be made. It will be made as per the norms, whatever be the norms of the bank.
Kindly see, with interest as against the investment made in fixed deposit. तो फिक्स डिपॉजिट का रेट पता लगेगा इंटरेस्ट हुजूर, साफ लिखा हुआ है इसमें ऑर्डर में. Determine the up-to-date maturity value with interest as against the investment made in fixed deposit. What more is required, Millers?
That's
It is very unambiguous. A scheme at Bokaro Steel FDR as per the details given in para 1 of the judgment, so and so, so and so. So as per FDR, once this order has attained finality, Millers, no rule regulation will override this, being law within the meaning of Article 250 of the Constitution of India. Now, the circular that my lord says that whether it will be renewed on a FD account or in a SB account automatic, even if refusal of it, they have refused, we have not. Kindly appreciate, my lords. If they would have, my lords, concurred, they would have acceded to our request for renewal. This could have, kindly see, imagine the situation, my lords. If you had approached them, and they could have conveniently renewed it, then, my lords, this question would not have come. Since they refused, we were, my lords, saddled with the litigation. And we approached the court, and the court passed an order holding them wrong. Even that was not honored. Then a contempt petition, personal appearance order was there. They appeared only then the payment. In that scenario, they cannot say that it was not renewed. Therefore, simple the SB account interest. It will be treated as an amount automatically invested in SB account. Then, what is the falling down? That by deeming fiction after 2004, it will be deemed to have been deposited in SB account. Therefore, the rate of SB account will carry after 2004, which is not the at all case here. Rather, their conduct will show that if my prayer was not acceded upon for renewal, it will carry the interest of FD account, not the SB account. Otherwise, what will the interpretation? That in 2004 the amount by deeming fiction is to this maturity proceeds deposited in the SB account, which is not the case here, unless they show that this amount was already deposited in SB account. How the SB account interest will carry? If they could have also so much so gracious enough that no, we will not renew, we have already paid the proceeds by closing the FD account and deposited in the SB account, therefore SB account interest will carry, I could have lost out of court. Even they are not pleading to that extent that this 2004 amount was credited in the SB account. Even for SB account payment, we have to make a prayer that please, they are not honoring the check for the SB account. So entire interpretation is against them. They are not entitled for any sympathetic consideration. By deeming SB account interest will come instead of this express order in my respectful submission. If their conduct would have been as such, I can understand this. But right from after taking the money, they are in constant breach. So no interpretation which can lean in their favor can be taken. 7 accept the interpretation which lean in our favor. So therefore, I am humbly submitting that the 2004 amount of proceeds maturity was not credited in SB account. They remained as it is. Even on date when the order was passed by the Honorable High Court, that was not credited in the SB account. They could have dissolved the FD on their own. If not renewed, they could have credited in the SB account and they could have honored the check. Then I could have understood that no, since in 2004 that has been credited in the SB account, therefore it will carry the interest of SB account. But it is not that fact. Fact remains that till the order was passed, they have never deposited the proceeds of the FD account in SB account. Therefore, the Honorable Court says that no, calculate the up-to-date interest on FD value. Determine the up-to-date maturity value with interest as against the investment made in fixed deposit scheme at Bokaro Association by FDR. Therefore, with all respect and humility, I beg to submit that this paragraph, if you read in background of the totality of the facts, there is no other interpretation than the interpretation that the court wanted. that you calculate the maturity value as against the FDR as per FDR rate of interest. If we have calculated 12.5%, they are not at loss with us. We have calculated 9%, they are not at loss. Then I am entitled for 13.5% and 12.5%.
ठीक है, आप बताइए क्या बोलना? What do you have to argue?
Madam, we say, madam, we have taken into interest the rate at the rate of FD up to the year 2008. That was an error on our part. But since we are not filed any case, madam, we are not seeking to recover, madam. We have paid in excess 59 lakhs and not, madam. We have said in our counter supplementary counter. We said first, as I said, madam, my first objection would be section 48, madam. Is there an alternative remedy? Secondly, madam, he had filed an interlocutory application seeking permission of the Honorable Court to withdraw the contempt application in terms of payment of rupees 2 crore and 29 lakhs. Since he has unconditionally agreed to it, he cannot re-agitate the matter now. But thirdly, madam, I have annexed the circular of the RBI, madam. Though I could lay hands on the circular of 2016, madam, I could not lay hands on earlier circular, which says, madam, if it remains unpaid, it will carry 7 bank rate of interest. If it not succeeds. My reply to the affidavit dated 14th of May 24, madam. I have annexed the circular of the RBI, madam. Page 17 onwards, sir. Relevant is at page 18, madam. Clause 9. Interest on overdue domestic deposits. A. The rate of interest to be paid on renewal overdue on deposit shall be subject to stipulation contained in section 4 of this directive. B would be relevant. If a term deposit matures and proceeds are unpaid, the amount left unclaimed with the bank shall attract rate of interest as applicable to saving account to the contracted rate of interest on the matured TD. However, whichever is lesser, lower. Then they have given the chart. In terms of this, madam, what he was entitled to was saving back rate of interest, and that we have calculated and paid. He's trying to stretch the order of the
Yes,
Honorable
I am
Court.
grateful for reading this clause. I have not read. What is said below? The term deposit matures and proceeds are unpaid. The amount left unclaimed. Is it a case, my lords? I am in a litigation right from beginning. Is it unclaimed situation? They are talking about what? When the amount is unclaimed. Nobody is coming to claim the amount. And therefore, why it should be SB account interest? That one should not feel that पैसे छोड़ दो आराम से बढ़ता रहे. So therefore the circular says what? Unclaimed with the bank shall attract rate of interest as applicable to saving account. It is not that case, unclaimed. Litigation. So this goes in there against them, it is in my favor.
Secondly, he has argued that FD was refused to be renewed. It was refused. Sir, I am not disturbed you, please.
When did you apply for renewal and when
Yes,
was
sir,
it
beginning.
refused?
No,
Since
no.
beginning.
He
Where
applied for
is
renewal with
it? Where is
retrospective
it?
effect.
Where is it? Where is it?
When
When did you apply for renewal
This
and
is
when
order.
did they refuse?
This is in order itself. Can you see this?
No,
Yes,
I was just trying to find out that only, but I could not get.
Then that rate petition has to be brought
नहीं
before
नहीं
lords.
उस रिट पिटीशन से क्या मतलब है? ऑर्डर पढ़िए आप.
Lords, prayer में ही क्या लिखा?
Where is your date on which you applied for renewal and what is the date on which they refused to renew?
Yes.
Then that rate petition entirely brought on report.
You just no, nothing is required. You just see when was it? When did it mature? What is the date of maturity?
First maturity was that chart
Not
that
the
I showed.
first, the last maturity.
Last maturity.
Yes.
2004.
No, last maturity was 2004.
Which was
Okay. And when did you apply for renewal?
for proceed.
When
We
did
apply
you
for the
apply?
proceed immediately
When?
thereafter.
When?
No, when? 2004 itself.
No.
Where is it? Show
Plus
us.
that is the plus kindly see the. Therefore, I am saying plus that writ petition is required now. Why I will come in the court, Milors? After all option was exhausted, who will come to the High Court for taking payment of the FD amount? After 2004, they were neither paying nor renewing nor doing anything. Then in 2008, we approached the court. Kindly see, Milors. So and so, which was refused to be renewed after 21/3/4. In my prayer itself, kindly have a clear pleasure, my lords. Which was refused to be renewed after 21/3/4 and accordingly to renew the same with retrospective effect till
Yes.
the date of sale. Yes, let us see.
What was played was he wanted.
सारा लिखा हुआ है भाई. What is the order?
Renewal with
Entire thing is clear. Well, kindly see this. Why I have made this prayer renewal? Because if tomorrow you are paying, you pay with the maturity proceed according to the interest of the FD. That is the intention of that prayer. You cannot go by the word, you have to go by the spirit. Kindly see this. Which was refused to be renewed after 21/3/4 and accordingly to renew the same with retrospective effect. Kindly appreciate my lords. Till the date of liquidation. क्या मैं कह रहा हूं कि जिस दिन पेमेंट हो रहा है उस दिन तक रेट्रोस्पेक्टिव इफेक्ट से इसको रिन्यू करके लिक्विडेट कीजिए. ये मेरा प्रेयर है.
This was not allowed.
Not allowed. That is expressly allowed. Kindly see this now. So kindly see the prayer. Why it was the prayer was made? After 2004 they refused, not paying. Then I made a prayer. What? Refused to be renewed after 21/3/4 accordingly to renew the same with retrospective effect
As it
till the date of liquidation.
Where is the
तो
request
जिस
from
दिन
you?
पेमेंट हो रहा है उस दिन तक का आप उनको एफडी का रेट्रोस्पेक्टिव रिन्यू करके पेमेंट कीजिए. ये प्रेयर. पेमेंट तो मांग ही रहे हैं लेकिन हमको उस दिन से लिक्विडेट रिन्यू करके हमको पेमेंट कीजिए. ये मेरा प्रेयर था. अब आगे देखिए क्या है.
What was the FIR for?
एफआईआर तो वो लगता है कि सोसाइटी में एफआईआर हुआ था वो जमीन उमीन का उसका था, वो मेंबर लोग का. ये जो पैसा था वो
FIR की कहानी क्यों है इसमें?
कहाँ पर एफआईआर का कहानी होगा.
FIR का कहानी है. There was restraint order passed. There are so many stories behind that. FIR BS case number 329 of 1996.
We have mentioned the writ petition entire background facts.
Also.
According why they were not paying, then certain members filed an FIR against us. कि भाई ये जो पैसा इन्होंने लिया था मेंबरशिप बनाने के लिए. हाँ पूरा पढ़ देता है. याद कर लिया.
नहीं दिया गया था इसके लिए FIR हुआ.
तो वही तो बता रहे हैं भाई. प्रेयर हम बता रहे हैं
पैसा
ना.
नहीं दे रहे थे उसके लिए.
क्यों पूरा बात आप जानते नहीं. पहले हम बता देते हैं. सोसाइटी को हम 20 साल से देखते हैं. समझिए क्या हुआ कि जो पैसा था वो नए मेंबर लोग बने थे, उनको लैंड देना था. This money was collected against the membership and deposited in the society, this bank. When they could not get the land, they filed an FIR. Somebody gone in was consumer forum also. FIR was ultimately was not found tenable for not allotment of the plot. The consumer forum awarded heavy interest upon us. As another background facts, I am not going on all that because I was only on the issue of the banking norms, fixed deposit, interest and the order of the court. Therefore, let me read the whole order then. Brief fact, petitioner is registered cooperative society bearing so and so, who are the employee of the so and so. Appears that in 1973 on request of the petitioner, the company request agreed to allotment of so and so addition, adjoining the previous allocated 19 acres of the land to accommodate rest of the 170 members. However, land was never leased out, transferred in the favor of the society due to the reason the management of the petitioner society has collected the development charge from 173 members, an amount of which 31,350, each totaling to 65 lakhs of money. However, due to the non-allotment of the land, the aggrieved members filed a complaint before the Assistant Registrar Cooperative Society, Charles Bokaro, who in turn lodged an FIR, being BS so-and-so, corresponding to GR number so-and-so, therefore said irregularities against the office bearers of the society. The petitioner submits that it has bona fidely, in order to keep the money safe, and Shiokor invested the same in fixed deposit scheme with the respondent Central Cooperative Bank. In the meantime, the inquiry investigation was completed and the final form was submitted by the IO on 9/98 with the conclusion that it is a case of mistake of fact, no offence is made out. It was also recorded that the amount collected from the members was neither misutilized nor embezzled, and thus the stay order passed by the police got vacated, expired automatically on the conclusion of the investigation. According to petitioner, pursuant to the investment made in the fixed deposit with respect to FDR number 2871, the same matured on 21/3/98 and it was renewed initially till 21/3/2001 and then up to 21st March 2004. But thereafter, neither the request for renewal was accepted nor the payment was released. Kindly mark this line. This is the submission. In the aforesaid background, the petitioner submits that when the land in question was not transferred to the society by the company for onward allocation and handing over the same to the members from whom the development charges were collected, they started pressing hard for the refund of the same, but the society being financially crippled due to the aforesaid arbitrary and illegal withholding of the matured amount by the respondent bank, and thus the petitioner was unable to refund the same. Resultantly, several cases were filed in the District Consumer Forum by those members against society, which would be evident from letter number 705/2002 dated so and so, written by the then Honorable Secretary of the Society to the officer in charge, BSCT Police Station. But again, of no avail. The petitioner society approached the respondent bank and requested to release the amount so as to liquidate the same for onward repayment to its members, but the respondent paid no heed to the same. It is also stated that the check of rupees 6,000 in favor of the one Vijay Bahadur Singh was not even honored by the bank. The petitioner thereafter also served a legal notice through counsel on 25/7 to release the admitted outstanding amount with interest, but the bank is sitting tight over it. Petitioner further submits that a series of orders has been issued by the District Consumer Forum Bokaro as well as the State Consumer Forum Ranchi in favor of the one or other members for payment of their amount deposited, but due to the arbitrary attitude of the bank, it could not be released. It has also been submitted that the amount deposited in Allahabad Bank has been released in favor of the society without any obstacle, and it is in this background that the present writ petition has been filed with a prayer as indicated in paragraph 1. The main ground raised by the learned senior counsel Sri Anil Kumar Sinha appealing for the petitioner is that the bank has no legal or justifiable ground to withhold the arbitrary amount deposited by the society in bank, and the entire action of the bank is arbitrary, malafide, and capricious, and thus illegal. It has also been submitted that the action of the bank is divorce the agreement and contract, and the FD amount matures has to be refunded based on matured value with the interest. The counsel for the petitioner further argued that the action of the respondent bank constitutes offence of cheating and defalcation. It is violative of Article 1493 of the Constitution of India. It has also been contended that the bank is only a licensee and is duty bound to refund the matured value of the amount to the beneficiary, and it is no authority to withhold the amount to deposited invested. It has further been contended that the pursuant to the order being passed from the time to time by the District Consumer Forum as well as the State Consumer Forum, warrants were issued against society, and it is the bank which is creating hurdle in refunding the payment made by the members who deposited their amount and are seeking refund of the same, but due to the arbitrary malafide attitude of the bank, the money cannot be refunded to the members of the society. The counsel appearing for the respondent bank has raised a preliminary objection with regard to maintainability of the writ petition. It is submitted that the administrator of the society who has sworn the affidavit was appointed by the order dated 150 dated 14/11/7 for the period of 3 months, and that the period has expired in February 2008. Thus, he is not competent after 12/2/2008 to institute the instant writ petition in March 2008. It has further been submitted on behalf of the respondent bank that the criminal case bearing BSCT case number 329/96 was registered, and during the pendency of the criminal case, the investigating officer by this letter dated 11/10/96 requested the answering respondent to suspend the operation of the bank account of the society. It has further been submitted the audit team found several discrepancies in the bank which has led to filing the criminal case registered while case number such and such, and it is in the interest in this background the managing company of the bank in its meeting held on 16/4/2 resolved to suspend the account of the petitioner society. And you see the approach, this my account, bungling is in your bank, suspending my account. What for? And they are saying that after 2004 we will pay from SB account on hypothetical ground. Neither renew nor liquidation. This is the pleading. I have gone through the pleading. Heard the rival contentions raised by the counsel for the parties. The bank is only a licensee to keep the money deposited further to refund the same on maturity without any obstacle. The first contention raised by the petitioner with regard to the pendency of the criminal case number such and such, an order of the investigating officer to suspend the operation of the society is not only misleading but erroneous for the sole reason that the pursuit to the completion of the investigation, the inquiry in final form was submitted by IO himself on 9/98, concluding that it was a case of mistake of fact, no offence was made out. As alleged, hence neither the amount was authorized collected from the members nor the same was misutilized or rebellion. It will thus be evident.
Murari, the circular which they have annexed
That's it.
is not relating to the period 2004.
Plus, even if they are relying, it is in my favor. They say unclaimed.
Reliant से नहीं होता है ना.
तो हम
Bank
डायरेक्ट
में
लाइन बोल ही रहे थे कि 16 का अप्लाई नहीं करेगा मेरे में.
नहीं करता है.
फिनिश्ड.
लेकिन कौन सा सर्कुलर अप्लाई करेगा
उसको
वो भी
हमको
तो नहीं
समय
है
दिया गया,
ना.
हम
नहीं,
वर्क करते
समय
हैं.
इसके लिए नहीं हो सकता है. इसके लिए आप the circulars, they are guided by their circulars, and such kind of dispute cannot be resolved in writ jurisdiction. आप सेक्शन 48 में जाइए, अपना सर्कुलर लाइए,
रजिस्ट्रार है वहाँ,
RBI को पार्टी बनाइए.
रजिस्ट्रार तो कुछ करेगा ही नहीं. जो रजिस्ट्रार तो कोऑपरेटिव का इनका IS ऑफिसर होता है. He does not have ABCD of law.
ऐसा नहीं.
And be a separate entity.
Because this objection was taken in writ petition, this was not sustained. This objection was also taken when the writ
And
petition
the
was
earlier
heard.
writ petition, no?
Writ petition. Now once that is overruled, they have not challenged that finding.
No, this objection, we do not know whether it was taken in the earlier petition
Yes,
or
please, kindly
not.
see that I have read just now. Kindly see this.
That objection of section 48?
Yes, kindly see this. This is the writ. The counsel according to the respondent bank has raised a privilege objection with regard to maintainability of the writ petition. It is submitted to the administrator of the society who has sold the affidavit. ये हुजूर का काउंटर में
तो
उसमें भी
दूसरा
था।
बात है ना, 48
हुजूर उसका
48
काउंटर
में
दिखा देते हैं
alternative
ना,
remedy का
उसका
कोई
काउंटर में है, हमको याद पड़ गया, मेरा ही ड्राफ्ट की रिट था हुजूर साथ में, वो काउंटर भी पूरा हमको याद पड़ रहा है धीरे धीरे। वो काउंटर में इनका साफ साफ लिखा हुआ था कि 48 में जाइए, ये आर्गुमेंट हुआ था।
ठीक है, सुन लिया।
उसको हुजूर हम दे देते
WPC
हैं,
number 372
दो तीन जजमेंट हुजूर देना था ना, जजमेंट हुजूर दे
Arguments
देना।
concluded.
Hello sir, I am not
Monday को
concluded.
judgment. I have heard it.
Because kindly appreciate, because-
आपको जो judgment देना है दीजिए ना।
I have
देखिए adjourn हम नहीं करेंगे, हम
Tomorrow
सुनेंगे
को
रात। Tomorrow क्या?
हुजूर तो एक रात को तो समय दिया जाए खाली हमको, तो एक रात को तो दिया जाए कम से कम। हुजूर का तो क्वेरी है कि सर्कुलर देखिए, हम कोशिश करते हैं, हम देखिए आपका समय मांग रहे हैं, ज्यादा मांग नहीं करते। हुजूर पहले भी एक रात में हम कोशिश करते हैं जितना हो सके कर लें।
Counsel for the parties have almost concluded their argument. However, from the records of this case, the relevant circular, if any, of RBI
Judgments.
with regard to the rate of interest on the amount of fixed deposit which remains with the bank after the date of maturity is not on record. The learned counsel for the petitioner submits that the matter be posted tomorrow. If he is able to lay his hand on the circular, he shall produce it before this court and he shall also file certain judgments.
तो उसमें लेकिन विदाई उदाई वाला फंक्शन है, सुनते हैं परसों मंडे हो जाए,
कल
इनको भी बोला जो भी सर्कुलर खोल के लाएंगे नहीं।
Burden of proof is on him.
अरे बर्डन तो है, वकील तो आप है ना, हम भी वकील, भले वकील के नाते बोल रहे हैं भाई, बर्डन का बात छोड़िए
ना
ना।
करना पड़ेगा।
ऐसा आप कहते हैं कि जैसे हम लोग का कोई ड्यूटी नहीं है कोर्ट के प्रति।
आइए क्या है?
आइए अर्ली हियरिंग का होगा, कुछ होगा अर्ली हियरिंग का, तो हियरिंग हो ही रहा है, अर्ली हियरिंग का क्या होगा, ये प्रोसेस है
Since
अर्ली हियरिंग।
168.
$33 लाख तो जो ये लोग कह ही रहे हैं कि हम देंगे, बट हमारा कहना है कि मेरा 33 लाख नहीं बनता है, उतना तक ये लोग एग्री कर रहे हैं कि 3.5 के
एक
अरे भाई, आप
सेकंड
उसमें बोलते हैं ना, हमको बोलने दीजिए,
इतना
जो लिखे
हल्ला
हैं।
मत करिए, ठीक है? लिखिए, दूसरा ऑर्डर लिखिए। WPC number 3728 of 2010. Counsel for the parties are present. The bone of contention between the parties is as to what would be the rate of interest on the fixed deposit which stood matured and remained with the respondent bank without any renewal. आपका ऑर्डर डिक्टेट करना है?
सबमिशन है,
आपका सबमिशन लिखा रहे हैं?
ईमेल विद
A circular of RBI of the year 2016 has been placed on record. However, the fixed deposit involved in the present case matured sometimes in the year 2004. Counsel for the petitioner is directed to include Reserve Bank of India as respondent number 5 in the present case, who would file an affidavit in the present case regarding the norms which was applicable on the date of maturity of present fixed deposits and the rate of interest which might be payable by the respondent bank. This court is of the considered view that the petitioner is entitled for rate of interest as per the guidelines issued from RBI and nothing more. RBI के लिए appear करते हैं Mr. Pandey नीरज।
बोल देंगे।
Counsel for the petitioner is directed to serve a copy of the entire writ records to Mr. Pandey Neeraj Rai, learned counsel, who generally appears on behalf of RBI. By tomorrow, you serve it. The office is directed to bring the name of Mr. Pandey Neeraj Rai from the side of the respondent in the cause list. the newly added respondent is directed to file affidavit in the present case strictly in connection with, only to the counter affidavit in this case, only annexing the circulars or norms of the RBI which may be applicable in connection with the fixed deposits involved in the present case. हो गया सूट तैयार?
Grateful, was highly grateful. हजूरी
ध्यान रहे आपका कभी ये कहानी नहीं सुलझेगा, आपका वहाँ भी नहीं सुलझेगा, सूट में भी नहीं सुलझेगा.
यही
RBI will
रास्ता
bring
सर,
this up.
वो जो कह देगा वो तो कह देगा.
It is further made clear that the RBI is not concerned with the interstate dispute between the parties, and they are being made party only for the purposes of bringing on record the norms or circular of RBI, as may be applicable in connection with the fixed deposit involved in the present case. इसमें तो आपको भी कोई तकलीफ नहीं.
Lordship may fix a date.
डेट होंगे. इतना एजिटेटेड मत रहा करिए.
आप तो कहाँ agitated?
ना ज़्यादा एजिटेशन अच्छी बात नहीं है.
ये तुझे इतना अच्छा रास्ता निकल गया कि
जस्टिस डिलीवर करने का रास्ता बताना चाहिए, लड़ाई से कुछ नहीं होता.
आदमी है अब आगे उसको बता ही दे.
Post this case on 28th of August under the heading for final disposal, awaiting the affidavit of RBI.
बातें उसको अभी हम बनाएंगे.
हाँ पार्टी बनाएंगे.
आइए
रेडी. आइए क्लोज कर दीजिए.
आइए क्लोज कर.
RBI का एड्रेस है रिजर्व बैंक ऑफ इंडिया, ये कचहरी रोड, RRDA बिल्डिंग कचहरी रोड. एड्रेस भी हम ही बताएंगे. रांची में रहते हैं कि दिल्ली में रहते हैं थ्रू द रीजनल डायरेक्टर.
वो ब्याज पड़ गया जो DRT के ऊपर. हम बहुत कम से DRT जाते शुरू में ध्यान नहीं देता.
Item 2, WPC 6716 of 2012.
यस पिटिशनर बताइए.
It is a challenge of order dated 12/1/2011 in Lecture 5, whereby my lord, the subject officer my lord, passed the order under section 6 of the BPA Act and directed the petitioner to remove the structure over the land without hearing the petitioner. And second order is my
Ex
lord,
parte order.
my lord,
You did not file your show cause.
I have filed the show
Then why
Without
no hearing?
without hearing.
From where do I read from this order that no hearing was given to you?
My lord,
From where do I read from this order that you did not appeal?
in Lecture 5, my lord. Lecture 5 my lord, page 37 my lord. प्रस्तुत बात इसको
Who is in possession?
मतलब
Possession में कौन है?
पोजीशन हम
आज के दिन में possession में
आज का
कौन है?
पोजीशन हमको नोट कर आई हैव फोर्सिबली रिस्पोंडेंट नंबर जो है ये प्राइवेट इसको पूरा इसीलिए हम इनसे पोजीशन के साथ हम 80 लाख कंपनसेशन का बीच में ट्रेड किए. हमारा थर्ड क्लेम है.
आपका show cause कहाँ है? Where is your show cause which you had filed?
So called my so called is
Let me see what is the content of your show cause.
so called
यही.
in Lecture 3 my lord.
पढ़िए जरा क्या क्या point आप लिए.
Under BPL Act, this learned code cannot be decided between the DISCO and this opposite party. That the petitioner is the physical possession of the land since last 50 years. That under the provision of Bihar Land Reform Act, petitioner is entitled for settle of the land in question. That under no circumstances land in question can be said to be public land. Then the answering the opposite party is prepared to grant evidence as regard to the period of position on the next day to the fixed for evidence that the statement made by the plaintiff are false, motivated and are against the provision of law, create that application of the एप्लीकेंट ये भी दिए थे। उसके बाद ये एप्लीकेशन एक दिए फिर 2010 में, ये प्रोसीडिंग 94 से चल रहा था, 2010 में दिए कि ये
आप
प्लॉट
कब
में
से पोजीशन में है, उसका क्या प्रूफ है आपके पास?
हम तो ये रिकॉर्ड से मतलब अभी जो सर्वे हुआ वो 80 से हमको पोजीशन शो कर रहा है, एनेक्चर 1
80 से पोजीशन
शो कर रहा है, लेकिन हम 50 इयर्स से
कहाँ से, क्या चीज़ है आपके पास?
मतलब
क्या चीज़ है आपके पास बताने के लिए कि 50 इयर्स से आप पोजीशन में हैं?
नहीं, वो तो मेरे पास
ना
नहीं
तो
है।
कोई रेंट रिसीट है,
नहीं, रेड शीट नहीं,
ना कोई डॉक्यूमेंट है। यू आर क्लेमिंग एडवर्स पोजीशन।
एनेक्चर 1 काइंडली सी मैंने
आर यू क्लेमिंग एडवर्स पोजीशन?
यस मैडम,
Go and get it declared from the competent court of
वो
civil
ठीक
justice.
है, लेकिन ये जो बीपीएलई एक्ट का जो प्रोसीडिंग चला है वो ही गलत है, मेरा ये कहने का है। ये जो इनका जो लीज डीड है उसके अनुसार से हम उसमें नहीं आते।
This property is not included in the lease deed.
नो, काइंडली सी
In the lease deed,
एनेक्चर
this property is not included.
नो मैम,
From where do you say this?
Yes.
Annexure 3 में तो कहीं नहीं है, this property is not included in the lease
काइंडली
deed.
सी लीज डीड मैडम,
What is the
पेज
description of your
67 ऑफ माय
property?
डीड एप्लीकेशन,
page number?
पेज 67
67.
पैरा 7 लीज डीड का है, लास्ट 2 लाइन मैडम।
What is the description of your property in which you are there? Though it is not your property, you are claiming adverse possession with regard to which property? Description बताइए अपने property का.
ये
कहाँ है आपका description?
प्लॉट नंबर ये दिया हुआ नेक्स्ट पेज में माय लॉर्ड, ये एनेक्चर 10 में दिया हुआ है, 11 में डिस्क्रिप्शन हम दिए हैं जो कि हमको दिया गया कि अपेंडिक्स ई में मेरा प्रॉपर्टी है, हम मांगे राइट टू इंफॉर्मेशन में।
This is RS plot number 4861.
मतलब दिन ये यहाँ उत्तर में दिनांक 20/8/2005 को नवीकरण की डी में मुताबिक अनुसूचित क्षेत्र जमशेदपुर
ये annexure 12 में RS plot number 4861 part area 3000 square feet. New plot number 2464. यही है आपका?
जी अपेंडिक्स ई में है, अपेंडिक्स ई जो है डीड में बाहर कर दिया गया उसको, पैराग्राफ 7 से देखा है पेज 67 में। The land forming part of the schedule 5 of the lease deed dated 1/8/85 on which Basti are existing have been excluded from the indenture area and the boundary of which shall be decided by the state authority by separate decision, which shall be made annexure to the land mentioned in appendix E.
Where is appendix E?
appendix E में ही हमारा जो करा
कहाँ है बताइए?
appendix ये नेक्स्ट दिखाए राइट टू इंफॉर्मेशन में appendix E में हमारा लैंड शो हो रहा है,
बताइए. Appendix E में कौन सा?
ये दिया गया
Page number?
पेज नंबर 81 जो राइट टू इंफॉर्मेशन से दिए हैं। हम सूचना मांगे थे सरमती रोड नंबर न्यू बारीडी पांडे मैदान 15 न्यू खाता नंबर 5 प्लॉट नंबर इतना टाटा लीज से मुक्त है या नहीं, खतियान में अवैध अंकित अवैध दखल 1980 से है जिसका माह और दिनांक दिया जाए। इसमें दिए दिनांक 20/8/2005 को नवीनीकृत लीज डीड मुताबिक अधिसूचित क्षेत्र जमशेदपुर पार्क नंबर 15 खाता नंबर 5 प्लॉट नंबर 2579।
आपका प्लॉट नंबर कौन सा है?
ये है
इसमें से?
मतलब मेरा प्लॉट नंबर ये
इसमें से बताइए प्लॉट नंबर.
हाँ, बता रहे हैं। मेरा प्लॉट नंबर है 2579 पार्ट 2581
2579.
मतलब 2579।
और ये प्रॉपर्टी ये जो RS प्लॉट नंबर किस में हुआ था? ये जो एनेक्चर 12 में देखिए RS प्लॉट नंबर 4861 है.
हाँ
इसमें है क्या 4861?
नहीं 4661 नहीं है, वो भी बता रहे हैं ना। इसके लिए जब प्लॉट चेंज हो गया न्यू सर्वे में आया तो फिर एक एप्लीकेशन इन्होंने दिया
नया प्लॉट नंबर 2464.
हाँ
इसमें है क्या 2464?
मतलब वो
ये
पहले
RTI में आपको 2464 नंबर दिया है क्या?
नहीं हमारा नंबर नहीं दिया।
तो फिर आप
ये
कैसे इससे मैच
proceeding
करोगे? हाउ विल यू मैच दिस?
मतलब हम यही बता रहे हैं ना, ये जो प्रोसीडिंग जो चला है ये चला है इस प्लॉट पर,
कौन सा प्लॉट?
नेचर
Show me.
ये प्लॉट नंबर चला है 4861 पर,
हाँ, 486.
ये 4861 पर चला है। हम इसमें ऑब्जेक्शन दिए, ऑब्जेक्शन देने के बाद इनका देखा जाए उनको कि एनेक्चर 4 दिखाया
Annexure 4.
एनेक्चर 4 में ये दिए पिटीशन फॉर अमेंडमेंट इन द रिस्पेक्ट ऑफ द लैंड रिकॉर्डेड बाय द अपोजिट पार्टी। अब इसमें जो है इसको चेंज कर दिए कि ये नहीं होकर के ये हो, न्यू सर्वे प्लॉट सो एंड सो। But till date, this application has not been allowed by the competent authority. ये ऑर्डर
Yes, respondent.
पूरा ऑर्डर
Respondent.
जो लगाए हुए हैं।
Are you there? Yes. You sought some amendment.
Yes, that was
Was
allowed.
it was it
Not
allowed? When was it allowed?
Annexure 5.
Annexure 5 is not dealing with this property.
My name is Mayan. दोनों लिखा
कहाँ दोनों लोग?
बच्ची को नोटिस का मामला के उपरांत ये उपस्थित हुए तथा उनके द्वारा आवेदन समर्पित किया गया जिसमें कहा गया है ऐसा
Was this amendment allowed? Because you are changing the plot numbers.
जिसको द्वारा इसमें पढ़ना जिसको द्वारा
सुनिए ना, उससे नहीं,
इसको
आप तो
द्वारा-
जो सवाल पूछ रहे हैं ना, आप उसका जवाब दीजिए. You sought an amendment
जी
with regard to the description of the property.
जी
Does the petitioner not have a right to respond to that?
उसके बाद नेक्स्ट पैराग्राफ में लिखा हुआ है कि बच्ची को नोटिस का मामला के उपरांत वे उपस्थित हुए तथा उनके द्वारा आवेदन समर्पित किया गया। इसमें कहा गया कि प्रश्नगत बात 1277 वर्ष 94 का है जबकि नोटिस दिनांक 25/9/97 का है। उनके द्वारा कारण अपेक्षा दाखिल करने के हेतु समय की मांग की गई। पुनः विपक्षी द्वारा आवेदन दाखिल किया गया। इसमें कहा गया कि प्रश्नगत भूमि पर विगत 5 वर्षों से उनका दखल कब्जा है। उस पर द्वारा प्रश्नगत भूमि का खतियान की सत्यापित प्रति संलग्न किया गया है। विपक्षी का कहना है
एनेक्चर 5 में उसको कहा गया कि एप्लीकेशन दी है, लेकिन
क्यों आप बोल रहे हैं? जब हम उनसे पूछ रहे हैं ना, आपसे कन्विंस होकर पूछ रहे हैं, नहीं तो आप ही से पूछते रह जाते हैं.
विपक्षी का कहना है कि दिनांक 18/9/2008 को किसको के बहुत सारे पदाधिकारी उन्हें प्रश्नगत भूमि से बेदखल करने के लिए
सर सुनिए एक सेकंड सर, प्लीज होल्ड ऑन जस्ट अ मोमेंट. दिस अमेंडमेंट वाज फाइल्ड ऑन 1/9/2010 annexure 4, right? Thereafter, and his show cause was filed prior to this. Okay, in the year 2009 he filed his show cause. You filed your amendment in 1/9/2010. Was there any further show cause? Did your authority call for any further show cause from the petitioner?
इसमें कि रिकॉर्डेड है कि अमेंडमेंट फाइल की।
हाँ तो बस
That is the only record.
तो yes, you changed the description of property and without calling for any further show cause.
But yes, he has participated in the.
Might be he has participated. How does he know?
But,
No,
but he has not challenged this in this
need not.
subsequent order.
कुछ नहीं, उतना बहुत है. इतना उनको पता होता तो इतना दिन से केस पेंडिंग थोड़ी रहता. It is very very simple. You see, once there is an amendment, you should have called for a supplementary show cause. As simple as that.
Whatever it is,
Amendment के बाद यहाँ काउंटर सप्लीमेंट्री फाइल करते हैं कि नहीं?
like उसके बाद इसमें जो फाइंडिंग दिया गया है, इसमें कर का जो फाइंडिंग है, that takes care of the new plot.
No, you do not know whether it is a corresponding plot or it is not the corresponding plot. Who knows about it?
That is our petition.
So he has a right to respond to this amendment petition.
But now the question is, main ground was that this application itself is not maintainable.
Maintainable, not maintainable. We will not say this. We will say that he will respond to this amendment petition.
So already by this in supplementary affidavit we have said.
He has filed his show cause prior to this. There is
Yes.
no
But
supplementary
the
show
question
cause.
is that the question is, as on date, we have already placed on the second supplementary affidavit that the entire plot is converted into a park.
We will not hear that. We are not hearing appeal against that. We are in writ
But the
jurisdiction.
status of land today is different. That is
You just confirm the same order, but allow him to respond to this amendment petition.
who will hear this matter?
The deputy collector will hear the matter under BPLE. He will hear the matter.
He has appeared after the amendment application was filed. He
No,
was heard.
no. He appeared prior to that.
Then
Sorry.
where 836 is
ने appear किए
They appear किए हैं, but
Appear किए,
amendment
but
allow हुआ
amendment
क्या?
allow- amendment till that amendment has not
But
been allowed.
just a question is that fact has come that this amendment application was filed. Thereafter he has appeared.
So what?
Contested the proceeding.
So what?
Is he not stopped from challenging this? That
Para 10 का क्या response है आपका? He says that it was not allowed. How do you respond to para 10?
But then that question that he was in possession of the
इनका
property.
काउंटर दिखाइए.
Possession of the property जो वहाँ discuss है.
कोई
That
बात
is the
नहीं.
new-
वैसे भी डिस्पोजेस ने क्या होने वाला है? हियरिंग करके एक ऑर्डर कर दीजिए. आपको जो करना है करिए. Where is the response to para 10? What is this? Such evasive reply you have filed.
स्टेट के द्वारा पारा 10 का दिया ही गया जवाब.
Respondent number 5 भी तो ऐसा ही एफिडेविट फाइल. स्टेट कहाँ है? स्टेट का रिप्लाई.
स्टेट का ये 3 4 4 में भी काउंटर. और जो पैराग्राफ 18 में बोले हैं ये लीज डीड का और जो दिखाए हैं कि ये लैंड जो इसके बाहर है उस पर उनका कहना है पैराग्राफ 18 का with regard to the
Oh,
state.
they have not given parawise reply. State has not given parawise reply. Very good. They have done it at their own peril. We don't bother about it. They have done it at their own peril. We don't bother about it. They don't bother. अपना कहानी सुनाते हैं बस. Right? This statement stands admitted. On this amended property details, he was entitled for a show cause. Okay. The learned counsel for the parties are present. This writ petition has been filed for the following relief. The learned counsel for the petitioner submits that the petitioner is in possession of the property involved in the present case for a long time. However, a proceeding being BPLE case number 1277 of 1994 was initiated. With respect to the property being in Moza Nildi, Khata number 71, RS plot number 4861 within bracket P, bracket close, area 30,000 square feet. Corresponding to new plot number 2464, Khata number 5, ward number 15, area 30,000 square feet, at the instance of the private respondent. The learned counsel submits that the petitioner had filed the show cause reply by annexure 3. Date क्या है annexure 3 का?
Annexure 3 में page 35.
Date.
Date was 1910. 1910.
dated on
No,
1
119 पहले का dated 11/11/97
11/11/1997, and in the midst of the proceedings, one petition for amendment was filed by the private respondent who, and it was stated that on verification the new survey plot number was found to be encroached, that was bearing new survey plot number 2579 within bracket P bracket close, 2581 within bracket P bracket close, and 2580 of ward number 15 comma JNSC, and not in new plot number 2464 of ward number 15 JNSC. The petition for amendment was filed on 1/9/2010. He has referred to paragraph 10 of the writ petition to submit that the said amendment petition was not allowed by respondent number 3. The learned counsel submits that, however, while passing the impugned order, the authority passed an order of eviction with regard to the property which was mentioned in the petition seeking amendment. The learned counsel submits that neither the petition was, since the amendment petition was not allowed, under such circumstances, the order of eviction with respect to the property mentioned in the amendment petition could not have been allowed. He further submits that upon the amendment being allowed, the petitioner would have had a right to respond to the amendment. The learned counsel submits that the petitioner has been prejudiced on account of the order of eviction having been passed on with respect to the property which was mentioned in the petition seeking amendment. Counsel for the respondents have
only one submission. In the operative portion of the order, विपक्षी को बिहार झारखंड लोक निधि अधिनियम की धारा 6 के अंदर जो सुधारा के अंतर्गत विहित प्रपत्र में नया सर्वे प्लाट नंबर का सत्यापन के पश्चात प्रश्नगत भूमि का नया प्लॉट दाखिल कर अतिक्रमण हटाने की that means opportunity was given.
The learned counsel appearing on behalf of the learned counsel appearing on behalf of the private respondent has referred to the impugned order to submit that there is an order to evict the petitioner from the property mentioned in the amendment petition. It goes to show that the petitioner is in illegal possession of the said property. A counter affidavit has also been filed on behalf of the private respondent, in which no specific response has been given with respect to the statement made by the petitioner that the amendment was not allowed. The learned counsel for the state has also opposed the prayer, but the counter affidavit of the state does not deal with para-wise comment, but general statements have been made.
The question is not if
After
this
hearing the learned counsel for the parties and considering the facts and circumstances of this case,
General statement. Para-wise comment is there, but
कहाँ है पैरा 10 का रिप्लाई?
para-10 का reply, specific reply नहीं.
बताइए कौन सा पैराग्राफ में पैरा 10 का रिप्लाई है?
Page 3 में para-10.
Page 3.
The earlier counter affidavit.
2-3 काउंटर तो आप लोग फाइल ही करते हैं
7 पेज
मिनिमम.
का काउंटर ही 7 पेज काउंटर
कौन सा डेट है इनका?
ये हमको रिसीव करा है 11/1/2013 को
7-13
7-1-13. The learned counsel appearing on behalf of the state has referred to the counter affidavit dated 7-1-2013. However, from the perusal of counter affidavit, no specific reply has been given with respect to the statement made in paragraph 10 of the writ petition, wherein it has been mentioned that amendment was not allowed. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, it is not in dispute that initially the
Eviction is from this new floor.
initially the proceeding was initiated under BPLE with respect to the with respect to description of the property as that is Moza Nildi, Khata number 71, RS plot number 4861 within bracket P, area 30,000 square feet, and the corresponding new plot number was stated to be 2464, Khata number 5, ward number 15, area 30,000 square feet. The application was filed by the private respondent. The petitioner had responded way back as on 11/11/1997 within bracket annexure 3. However, the matter remained pending and a petition seeking amendment with respect to the description of property was filed on 1/9/2010. It has been specifically stated by the petitioner that the amendment was not allowed in paragraph 10 of the writ petition, which has not been denied by the respondents in their counter affidavit. However, the order of eviction was passed with respect to the property whose description has been mentioned in the petition seeking amendment. This court finds that the order of eviction has been passed without allowing the petition for amendment, and on account of such fact, the petitioner has been prejudiced inasmuch as the petitioner did not get any chance to respond to the amended description of property, which was sought to be amended by the petition seeking amendment. In view of the aforesaid facts and circumstances, this court is of the considered view that the impugned order dated 12/1/2011, passed in BPLE case number 1277 of 1994, with respect to the property which was sought to be introduced through which was sought to be corrected through the petition seeking amendment, cannot be sustained in the eyes of law, and accordingly the matter is remitted back to the subdivisional officer Dhalbum Jamshedpur.
And also my lawyer accept your
Appellate order also. Okay.
you check your
Is on the similar ground, the appellate order as contained in BPLE appeal number 138 of 2010-11 dated 27/9/2012 is also set aside. Accordingly, the matter is remitted back to the court of subdivision officer cum deputy collector under BPLE Dhalbum and Jamshedpur. The petitioner would file a fresh show cause incorporating his objection with respect to the amended description of property as mentioned in the amendment petition as contained in Annexure 4. The said authority shall pass an appropriate order in connection with the prayer seeking amendment, and after hearing the petitioners as well as the private respondent, pass a fresh order in accordance with law after granting an opportunity of
petitioner is
hearing
not
of the
saying
parties.
that this is the plot which from which he
The
has
parties to appear before the said authority, I'll give a date. You appear and proceed. The parties to cooperate with the proceedings as the matter of eviction is of the year 1994, and the authority shall pass appropriate order as expeditiously as possible without granting any unnecessary adjournments and not later than 6 months from the date of appearance of the parties.
And after going to the merits of the case.
Certainly.
पैकेज में हमको इनका जो लगाए हैं
Just a moment. It will certainly be open to the parties to file their to file written submissions in support of their respective contentions.
records में
आपको जो करना है, verify the records and pass them. ये सब हम कर देंगे ऑर्डर में. Appellate order के बारे में थोड़ा हमको लिखना होगा, हम लिखेंगे.
Item 3, WPC 4130/2014.
Yes, petitioner. Yes, sir. Please, sir. आप ही का केस है? This is your matter, I think.
4130.
4130, yes.
This is of course Lord. Against answer 3, page 36.
Yes.
Before I come to this Lord, after take effort, I could contact one of the rice mill owner yesterday, and he intimated me that the money suit has been filed from our side
तब तो क्या होगा?
against the respondent, and that is pending over there, and witnesses are going
So
on.
you agitate the matter there only?
My lord,
Did you agitate the matter there? You'll have to agitate the matter there only.
impugn notice is demand of money against me,
Okay.
and that money suit.
You respond to this impugn notice and tell them that your money suit is pending.
Money suit is pending.
That's right. If you have a claim, certainly
I have a claim.
they cannot realize this money from you.
No.
You can tell them that your money suit is pending. You can respond to this notice.
Yes, I'm fighting that money suit.
You can respond to
But-
this
but-
notice.
but
This is
Lord,
at the
but-
stage of notice.
By this impugn notice.
When did you file the money suit?
My lord,
When did you file the money suit?
लिखता है कभी 14 नंबर 14 तो 2005 का फाइल किया हुआ है 2015 का
नोटिस आने के बाद आपने मनी सूट फाइल कर दिया रिकवरी के बाद कि रिकवरी के पहले? मनी सूट आपने रिकवरी के लिए फाइल किया होगा ना?
हम
तो
recovery के लिए
this
किया,
money
हमारा due है।
this money might have been this notice, pursuant to this notice, some
Notice
recovery
have been-
must have been made.
prior to that, prior to filing my money suit.
Yes, and thereafter you must have filed the suit for refund of the money.
Different owner claiming money because the
On
rice
what
which
ground?
was the rice which was milled,
Yes.
those rices were to be lifted by the concerned respondent. By not doing that, I have faced loss, huge loss, because
Yes.
rices are
You see, it is
for recovery
only.
of that loss, we will file the money suit.
Mr. Naik, we appreciate that. You have moved this court against a notice.
In notice is for that blacklist कर देंगे. Without giving any opportunity of hearing this threat. This is blacklist कर. अतः आपको निर्देश दिया जाता है कि इस पत्र के साथ संलग्न प्रतिवेदन के कलम में अंकित राशि कितना का निश्चित रूप से जमा करने का सुनिश्चित करें, अन्यथा विलंब किए जाने पर 18% ब्याज वसूली तथा संबंधित राइस मिलों के काली सूची में डालने का कार्रवाई की
कार्रवाई
जाएगी।
की जाएगी। किया नहीं ना है, ब्लैकलिस्ट में डाला तो नहीं है आपको। They say that they will initiate a proceeding to blacklist it. right? You respond to this notice. There is no
And
reason.
एक तो डेवलपमेंट और हुआ है जो कि हम इस पर फैक्ट में नहीं घुसाए, कल हमको पता चला कि they have also sealed my factory mill. I will have to incorporate this fact not in
You
this
see,
sealed
once the
application by
money
filing a
is
supplementary affidavit.
ऐसा नहीं होगा. Sealing हुआ है तो that is a subsequent development. You can
हाँ,
certainly.
that is subsequent development.
That is a subsequent development, and then you will have a separate cause of action. But so far as this notice is concerned, this is not a notice. This does not blacklist you. It only says that they will initiate a proceeding to blacklist.
To blacklist. No, they will blacklist.
No. कि कार्रवाई की जाएगी. They will
खाली सूची
initiate.
में डालने की कार्रवाई की जाएगी. हाँ.
So they have not put you on in the blacklist. They say that they will initiate a proceeding against you. You respond to this. You
हाँ,
tell them that whatever are the
अगर
developments.
ऐसा ऑब्जर्वेशन हो जाता
ऐसा ऑब्जर्वेशन हम कर देते हैं.
तब हो जाएगा हमारा काम.
हो जाएगा आपका काम. WPC number 4130 of 2014.
This order will not cause any
This
prejudice to
writ
the
petition
money
has
suit which is
been-
pending in the court.
आपका मनी सूट से इसका वो होगा ही जो भी आपका रहेगा. This writ petition has been filed for the following relief. काउंटर भी तो फाइल किया है लो.
काउंटर फाइल हुआ है. एक काउंटर में
सिमिलर सब लोगों का है ना. झालसा वगैरह भेजने का कुछ ऑर्डर. Okay, the learned counsel for the nobody appears on behalf of the state. This writ petition has been filed for the following relief. The learned counsel for the petitioner has submitted that the petitioner has assailed Annexure 3, whereby the petitioner has been asked to deposit certain money, and on account of non-deposit, it has been stated that steps will be taken to put the petitioner in blacklist. The learned counsel submits that the petitioner has filed a money suit which is pending before the court. After hearing the counsel for the petitioner and upon going to the records of this case, this court finds that a counter affidavit has been filed in the present case, wherein an order passed by this court dated 12/9/2014 has been annexed in WPC number 3629 of 2014 and other analogous cases. And with the consent of the parties, the matter was referred to Jharkhand State Legal Services Authority, and it was observed that if the matter is not resolved, the parties would be at liberty to approach appropriate forums seeking redressal of their grievance. As submitted by the counsel for the petitioner, the money suit has already been filed by the petitioner. The present writ petition has been filed only against notice. The petitioner, this court is not inclined to proceed any further in this case. The petitioner is at liberty to respond to the notice and bring the entire fact to the knowledge of the concerned authority. And upon such reply, the concerned authority shall pass appropriate orders in accordance with law before taking any adverse action against the petitioner. The petitioner shall do the needful within a period of 1 month from today. Authority कौन है? Respondent number जिला सहायक सहकारिता पदाधिकारी, डिस्ट्रिक्ट सब नहीं, who is the authority? District cooperative officer. The respondent number 3 shall do the needful. Deputy commissioner, सहकारिता पदाधिकारी. Respondent number 3 shall do the needful within a period of 6 weeks from the date of filing reply back.